Good afternoon, everyone. Welcome to the Appellate Division First Department. We have some 7 hours of argument time requested this afternoon, so please bear that in mind as I call the calendar and ask only for the time that you absolutely need to make your most important points. And please understand that we have your briefs, we have the records, we're fully familiar with the facts of the case. So, and if we need to continue with questions, we will. Okay. People versus Jeffrey Taylor. Submitted. Farmer versus Miso Securities. Six, 5. And did you want, I'm sorry, sir, you didn't ask for rebuttal. Did you want rebuttal? Yes, I'll take 2. Okay. 6, 2, and 5. Alfonso R. versus Ann B. Submitted. Greenpoint Mortgage versus Arenthal. Again, no rebuttal. Okay. 5 and 5. Heightman Credit Acquisition versus Meadow Partners.
Good afternoon, Your Honor. For the appellant, 10 minutes with 1 minute rebuttal, please.
We'll take a minute, just 1 minute.
8, 1, and 8. Thank you. People versus Ben Vontae Fogler. Submitted. Aurelius Capital versus Herz International.
The appellant, Your Honor, may we have 7 minutes plus 2 for rebuttal? Will respond in 8 minutes, please.
7, 2, and 8. Thank you. Hubard versus Apple Square LLC.
Respond in 4 minutes.
5, 1, and 4. People versus James Martinez. Submitted. People versus Abu Bakr Musa. 6, 2, and 6. WPC Billboard Lender versus Barakowski.
Appellant requesting
5 and 1 and 5. Blount versus Charter Communications.
Blount,
I beg your pardon?
you say Blount?
I said Blount versus Charter Communications. It's okay.
For the appellant, may we have 4 and 2, please?
Is there a respondent here on
Yes, I'm sorry, back here. Respondent requests 3 minutes, please.
3,
Yes.
4, 2, and 3? Quintana versus New York State Office of the Attorney General.
Good afternoon, Your Honor. For plaintiff, Quintana, 8 and 2.
Your Honor, for cross appellant, Khan, I request 5 and 1. Your Honor, for respondents, New York State Office of the Attorney General, Attorney General James, we request 7 minutes, please.
Okay. Six and 2. 5 and 1. 6 and 6. Thank you. City of New York versus Exxon Mobil.
Good afternoon, appellant requests 8 and 2. Respondents request 8.
7 and 2 and 7. People versus Laurel Del Rio, submitted. Szer versus Con Edison, we'll do them all together. So 4 and 1 and? 4-1, 4-1. Szer versus Con Edison, there are 2. 1 is submitted. Rios versus the City of New York, submitted. I'm going to take a case out of order. Number 11, WPC Billboard Lenders versus Barakowski. Okay, you can step up to the podium.
Good afternoon. May it please the court. We're here to discuss a fundamental issue regarding the application of the New York RPPL to foreclosures that are occurring out of state as well. The second department in Union Realty Partners established.
Counsel, in your brief, I noticed that you did cite to other jurisdictions. Do you have any case law from our jurisdiction that can maybe support your argument?
Again, Union Realty Partners, second department decision, held that RPPL 1370.
This is the first department.
So you're asking if do I have any first? There are no first department cases that.
Right, and so how has the first department interpreted these particular statutes?
The first department has not squarely addressed whether choice of law rules can cause should require a court to apply the substantive law of the RPPL to an out-of-state foreclosure. There's no case on point in the first department addressing that.
There isn't case law that particularly addresses RPAPL 1301 and 1371 subdivision 2?
There is case law in both the first and second department saying that the statute itself has no application to out-of-state foreclosures. However, the second department has stated that where choice of law rules dictate that the New York substantive law should be applied to the matter, the court will apply the substantive law of the RPPL despite there being no statutory mandate to do such. Again, the underlying case based upon which all the appellate divisions have stated that the statute itself does not have application to out-of-state foreclosures merely held that it was outside the contemplation of the legislator. This is Steinmetz, the 1930s decision of the New York Court of Appeals. The court merely.
What about Wells Fargo and against Bahana and Wells Fargo against Khan, which seem to indicate that 13013 it does not apply where the property is outside of the state of New York?
Correct. So the second department in FDIC also stated.
I'm really confused as to when we ask you questions about the first department cases that you continue to reference the second department cases. If you could address the first department cases, this is where we are.
Apologies. Again, as far as the first department has stated, as respondents have stated and as we've stated, that the RPPL itself does not apply to out-of-state foreclosures. Again, whether 1301 or 1371. And that's based on Steinmetz saying that the legislator did not contemplate its application to out-of-state foreclosures. However, the New York Court of Appeals in Padula regarding New York labor law went ahead and applied New York labor law, even though the New York labor law statute itself says that it is to be applied in New York. And the statute itself may not apply, but if the substantive law of New York should be applied to something that's out of state, the New York court will go ahead and do such when the choice of law rules dictates that such should be the case. And that's supported again by the second department decision in Union Realty Partners applying RPPL 1371 to an out-of-state foreclosure when a choice of law rules dictated that such should be applied. As far as the CPLR 3213 argument, the respondent did not address the issue of whether or not there was an affirmative defense of release. Appellant said we were released, and the respondent did not even in its reply credibly establish that the release was subject to a condition precedent, as the court in the transcript indicated, and thereby directed discovery on the issue. Therefore, when the court sua sponte looked at the record and saw that, oh, the text of the release is a condition precedent, like the respondent is claiming, there was no real opportunity for the appellant to respond to that. The respondent never met its burden on summary judgment under 3212B. Respondent was required to establish there's no affirmative defense. They failed to do that, and therefore.
Thank you. Let's hear from opposing counsel.
Good afternoon. Gil Fetter for the respondent. I'll go right into the RPAPL first, if I may. For the last 2 years, this court has been incredibly clear in the museum case last year and in the year before that in Taylor Bean that the RPAPL does not apply to foreclosures outside of the state of New York. In both those cases, you had a foreclosure outside the state of New York. Then in museum, the most recent case, you had a 3213 motion, just like here. In Taylor Bean, you had a 3212 motion. And then you had the sale.
What about this principle that your adversary's argument in terms of choice of law?
Okay. The cases he's relying on, while I don't think it matters, have the note and the property subject to New York law. We have a different scenario here. Our note is subject to New York law, but our agreement says the properties and foreclosures are subject to the laws in the state in which they sit. So that's the huge distinction here between those cases and ours, although I don't think you should be applying the Second Department case law to the First Department. You'd be reversing a long-standing history of cases before this court. I think one thing that is missing in his papers that you have to know is that he's not without his remedies in New Jersey and Pennsylvania. He's able to go get a fair market value hearing in those states and apply the credit. There'll be a valuation done just like you would do in New York, but you would do it in those states. New York can't tell those states how to run their foreclosures and what process to use. So after this matter is over here, you could be sure, like in all the foreclosure cases we have, he'd be running to those states to apply the credit, if you will, of the value of those properties. So there is no double recovery. The RPAPL 1371 is there, so there's no double recovery. You can't get money for the note and for the foreclosure. There's only one set amount you get. But what he's doing is he's trying to get out of the entire note because we didn't follow the RPAPL here. We couldn't follow the RPAPL here for properties that are outside of New York. We would have to go to those jurisdictions and do a valuation proceeding. There are no statute of limitations in New Jersey, so he can file that valuation proceeding at any time he wants, and I'm sure he'll do it, and get the credit for the value of the property here. So the protections afforded by RPAPL 1371 are there. So there will be no double recovery. Those states won't permit it. If I may just quickly move on to the 3212 and 3213 motion. We filed the 3213 motion. We had an oral argument on the 3213 motion. There was no decision except one granting the 3213 motion. The judge did say on the record, on the RPAPL, you're absolutely right. I'm not sure if this is a condition precedent or a promise, but she looked at the language, which is very clear. It says provided that, and all the cases we cite to say if it says provided that, It's a condition precedent. It's not a promise. Mr. Barakowski did not breach the guarantee by not providing that documentation that we wanted on time. He didn't have to. That's not a breach. So whether it's material breach is irrelevant. It's a condition. The guarantee becomes terminated if those documents were provided on time. In the real estate context in which we're in, where this is a $30 million loan, we need finality in agreements. And the case that we rely on most is the affirmance from Oppenheimer of this court's decision, where if the language is clear, like provided that, you have to strictly enforce it. And there's no reason that my client should have forfeiture if his client is the one who didn't perform and have the agreement terminated. If there are no questions, I'll sit down.
Thank you.
Thank you.
To clarify a few issues here, respondents stated that they could not have sought a RPAPL deficiency judgment in New Jersey. We clearly cited case law that New Jersey, in fact, would have permitted them to have gone through the process of submitting a motion to enter a deficiency judgment, which they failed to do. As far as whether this issue should properly be addressed in New Jersey, we have a judgment here in New York, and we're seeking that that judgment here in New York should be reduced or eliminated. This department in Szer held that the New York court didn't really have a business in deciding on whether or not an Arizona judgment has been satisfied by virtue of the fact that they failed to move for deficiency within 90 days in accordance with New York law, because at the end of the day, it was a Arizona judgment. So likewise here, the proper jurisdiction to determine whether or not the effect of the receipt of the proceeds of those foreclosure sales in New Jersey and Pennsylvania is a New York court.
Thank you. Thank you both. Armour versus Miso Securities. Just a moment, please.
Rick Ostro for the plaintiff appellant. So let me start off by pointing out that the lower court decision found that the termination, or at least it can be inferred from what's in the complaint, that the termination.
Could you just lift the mic up just a little bit?
Sure. Is that good? Better? Yeah.
Better, yes.
Okay. Thank you. That the termination was motivated in part by a retaliatory animus. So that finding is in there. That finding is not subject to appeal right now. The first problem with the lower court's decision is once you have the finding that the termination was motivated by a retaliatory animus, the case law is clear that that brings the remainder of any conduct that's part of a continuing practice into a hostile work environment analysis. The lower court's decision did not analyze whether or not a retaliatory hostile work environment existed. It didn't separate the gender claim from the retaliation claim when discussing the hostile work environment. And it's clear when you read this complaint from start to finish, and I know it's long, I apologize for that, but there's tons of detail in there, and it starts off with a complaint a lot of gender comments being made, a complaint being advanced, and the person who the complaint was made about says, I'm gonna get her fired. And then not that long after, that person, in fact, got her fired. That person, while the respondent tries to argue that Ms. Creange didn't have control over the desk, the reality is she was the interim head of the desk when the Passeretta was unavailable, and then she was made the co-head of the desk. And when she became the interim head and then became the co-head, that's when the downward spiral started for Kate Farmer, ending in her termination, which was the day after, or within 2 days and within 1 day of a complaint about the fact that Creange had made up a lie about her trading book. And that's the exact same technique that Creange used at the very beginning of the story which led to the initial complaint.
And there seems to have been a strange situation here relating to the a voluntary or not voluntary end of her employment, sort of a potential misunderstanding of an email that your client sent to the defendant?
Well, quite frankly, I don't think it was a misunderstanding, but what you can infer from the complaint is very clear. They said she resigned. She said she didn't resign. That's an issue of fact. If they're lying about the fact that she resigned, that is pretext. When you have pretext in a discrimination case or a retaliation case, the case law is very clear. It goes to the jury to decide, because a jury can reasonably infer that the reason why the company lied about how the termination happened was a pretext to cover up an improper motive, and from that fact alone, they can infer that it was based on either retaliation in this case or discrimination in this case. And discrimination and retaliation was absolutely a pattern right from the start, right to the end. And there's no question that it was connected, and there's no question that it all related to the same types of conduct. What was going to be her book? What was she going to be given? What was she taken away? And I would submit to the court that just one look at the chart that my client had emailed to her supervisors multiple times that shows the unbelievable objective disparity between her book and the books of her male counterparts. It jumps off the page that when she's then complaining about inequity and inequality and discrimination, it's clear as day what she's talking about. And if it wasn't clear enough, she said this is sexist and she's being treated differently because she's a woman. She flat out said you wouldn't treat a man like this. And this was a consistent pattern of behavior from the start of the problems to the day of the pretextual termination.
Could you address the issue about the statute of limitations as to when the timing of some of these events occurred?
Yes. There's no question that the only event that occurred within the limitation period is the termination. The only question is, was the termination part of a pattern? Because the case law is clear.
Continuing pattern.
Exactly. If it was
You're
part,
saying it's the culmination of that continuing pattern that brings in those events that happened in the previous 3 years.
I would say that's one way of looking at it, but is certainly the last act in a continuing pattern of finding ways to attack her, to make her life difficult, to make it harder for her to trade, culminating at the end of the pattern, with the last act being the termination.
And certainly your argument, part of your argument on that issue is that at least on a 3211 motion where there's been no discovery and just the complaint, which as you pointed out yourself is quite lengthy, there's enough there to at least get the case moving along to the next
Way more than
discovery
enough.
issue.
And I understand my colleagues' arguments. They're factual arguments, and they're good factual arguments, and he's welcome to present them to a jury. His inference a jury may accept, but a jury may also accept the fact that when she presented them with unequivocal in writing complaints about discrimination and said, I'm getting a lawyer involved, that they got worried and then pulled back a little bit. But at the end of the day, they got rid of her, and it was all one pattern.
Thank you.
Thank you.
Thank you, Your Honors. Edward Yannick for Respondent.
Counsel, I'd like to begin where we just left off, and the fact that this is a 3211A5 pre-answer motion, and we should be taking these in the light most favorable to the plaintiff. So how is this, tell me about why you believe that there is no gender discrimination here and the other claims that you're challenging.
So the gender discrimination claims essentially in terms of termination, right? And that is, to be clear, the plaintiff conceded below and is conceded here on appeal that in terms of the disparate treatment discrimination claim, The termination is the only thing at issue. So putting aside the hostile work environment, the motion court correctly found that there was no evidence of a discriminatory motive, right? Found differently as to retaliation given the proximity of the
Retaliation claim stands, right? Even
given the proximity of the complaints, right? The court noted that there were complaints that had been made, accusations of sexism, reasonably proximate to the termination, and so that was a separate matter. But the court found differently as to discriminatory motive. And so Ms. Farmer's allegations of sexism, accusations of sexism against her managers, it's not relevant to whether there actually was. What allegations, the question is she making in her complaint that speak to whether her termination was motivated by discrimination as opposed to retaliation? And essentially their arguments break down into comments that a female colleague who was not her supervisor, and that's clear from the complaint. I think they've tried to muddy the waters on that a little bit, but this person, Tracy Creange, was not her supervisor. There are allegations about performance reviews in here. Tracy Creange did not give her performance reviews. There's not a single allegation that she ever spoke with Creange about her assignments, not a single allegation that Creange ever talked to her about any of these issues. The allegation is that Creange...
Well, I think she says that she was treated differently from her male peers throughout her employment.
Right, and so there's the chart that my colleague alluded to that shows that there was...
and in terms of her share of the market, which was reduced, she said while male traders each had about 20 to 30% of the market with higher risk limits, she was different. She was also told that the firm policy prohibited her from trading preferred stocks, but then the male employee was able to trade them. I mean, she does go through a number of different examples.
I understand there are those allegations. As the motion court found, there's just say-so in terms of linking the alleged discrimination behind those decisions to ultimately the termination, that there was nothing connecting the termination itself.
But
And-
what about this concept of this continuing pattern that was the last act or the culmination, or however you want to put it, that's the termination. But all of these other things led up to that.
Again, it seems that it really is just sort of a say-so, right? So there's...
But we're
to
talking
say
about
that
a
it's a
30-11 motion, right? Like if this was summary judgment after depositions and things of that nature had been completed, then maybe there'd be a different position. But why isn't it enough to allege those facts?
I agree that the standard is what it is on a motion to dismiss. This complaint is a little bit unusual, and because it is so robust and there are so many facts in it, and we pointed this out in our briefing, there are...
That's a bad thing?
Well, let me use the tickers as an example. That is a snapshot of a particular time. I believe it's in July of 2020, so we're talking about 6 or 7 months before the termination. She complained. She had just gotten this trading book, right, because her old book was decimated and they were trying to sort of get her back up to speed. She gets this new book and immediately complains that she doesn't have enough tickers. And she shows this chart and says, this is how many I have, this is how many my male colleagues have. There's an admission in this complaint that that is then remedied. And ultimately, when they make a series of concessions to her, she claims that she is leading the desk by a mile in terms of her performance. So,
But then she said that changed.
she never says that her performance. No, that is actually at the end, right? That's basically immediately before the termination. She's referring to the January 2021
Doesn't she say it was her
period.
own work that turned things around, that it was her ability and her, how she was doing her job effectively that really turned things around for her?
She does allege that, but she also admits that they brought her up to, I think she said 15% of the index. She was alleging she couldn't make money with the book as it was after she initially lost her prior books. And then obviously she's admitting she could make money with it. So the point that I wanted to make is there's sort of a cutoff there, and I think the motion court at least implicitly recognized this, that there's sort of a chasm between the alleged discrimination as to the trading book and all of those things, and then ultimately the termination.
Thank you.
I just want to respond as to the chart itself. First of all, the chart was emailed multiple times on multiple dates. And not only was the chart which is emailed itself, but as described in multiple complaints, she specifically told her managers and complained about the fact over the entire series of time that she had less tickers, different types of risk adjustments that were made as compared to her male counterparts. And the most blatant example is when she finally fights and claws her way to get the pharma sector, and it's taken away from a man and given to her, she's given less risk than that man. So it's the same exact sector, the same exact assignment. A man had it and had a certain amount of risk, and now she's given less risk. And by the way, there's no explanation, at least at this point, because this is the motion to dismiss, for any of their actions. So for purposes of this motion, all their actions sound irrational in the complaint. I think we're going to ultimately prove that they were irrational and didn't make sense, but we'll see what they say in discovery. We'll see what the emails show. The fact of the matter is that my client has a right to get discovery on these matters, and the same thing on this issue of Creange and what amount of influence she had on the termination. They want to say that we made something of the complaint. No, she's the one who's sending emails to the entire Asian desk saying, don't give farmer preferred trades. She's the one who the boss, Passeretta, is saying, before I make a change, I'm going to check with Creange. She was made interim desk. She was made co-head of desk. She's the one who my client said had the most influence on her career when she complained. And again, she's the one who had the incident or caused the incident that happened a day before or 2 days before. It happened over 2 days, probably more, but only 2 that my client knows about, where she accused my client of lying. So unless there are further questions, I'm good.
Thank you.
Thank you.
Thank you both. Greenpoint Mortgage versus Arenthal.
Good afternoon. My client is seeking to intervene in an action where my client owns the property but is not the debtor on the mortgage. The trial court
Counsel,
dismissed our
to
motion to
begin-
intervene.
I'm over here. To begin, your client, I think, failed to proffer on a proposed pleading, which is, your client is the intervener, and right, and so your client, to begin, failed to proffer a proposed pleading, which is mandatory in a motion to intervene. But that's just sort of the beginning of it. Ultimately, even if this intervener application was successful, you would step into the shoes of Mr. Arenthal, who was the predecessor in interest from 2008. Isn't that right?
With respect to not having a pleading, there was already a judgment entered. There's no point in a pleading when there's a judgment entered, and we had
It's
cited
mandatory
that
in
case.
an intervener, so
We had cited cases.
even if you had that, don't you step into the shoes of Mr. Arenthal, who was the predecessor in interest, and he already had a judgment against him that was entered almost a decade before, in 2008. The property was foreclosed in 2009.
That's
And in
right.
fact, once you did get the property a little later on, you sold the property. You already transferred it to someone else.
We sold the
Your
property
client, I'm
as
sorry.
part of a bankruptcy where the money is being held in escrow while we debate who's entitled to it. Our argument here is that we should have the right as the property owner to intervene so that as the property owner, we can protect our rights because
The
had-
thing is, it doesn't even see, I mean, I don't think there's really a proceeding for you to intervene into. The case is over. There is a judgment. How do you intervene in a case that's over?
the case isn't over because there's never been a sale. And what happens in a foreclosure is they're required to conduct the sale within a certain period of time. They failed to do that. That's a statutory requirement. They made a motion to extend the time, at which point the judge granted it and said, I'm giving you so much time, and said that their actions in taking so much time were malevolent.
But
At that point-
you also waited at least 6 years after the judgment to even bring your motion.
Because we didn't understand that the lawsuit was still pending. They had abandoned this lawsuit and gone and started a whole second lawsuit, which was
The
dismissed.
lawsuit was of record.
I'm sorry.
The lawsuit was a matter of public record.
Absolutely matter of record, and if I'd been the attorney, I think I would have filed a notice of appearance a long time ago. But my point is, the lender failed to conduct the sale within the proper time by statute. They got an extension, and they failed again. Had we had the opportunity, which they didn't give us by not giving us notice, even though they were fully aware and relied on the fact that we were the property owner.
So even though everything becomes final, as my colleague pointed out, once the judgment was there, your position is that in this particular circumstance, you kind of got lucky because they hadn't made the sale yet. And
Right.
so therefore, you should be allowed to intervene at this point.
That's right. If we assume that we're back in time, we would have shown up at the second motion, had we gotten notice of it, and said, they've been sitting here for years. You've already dinged them once by not giving
So
them
what do
any
you expect is
interest,
going
and
to
you should
happen with the
not give them a
fact?
second.
What do you expect is going to happen with the fact that there is a judgment to foreclosure and the sale hasn't taken place yet? What's happening next in that regard?
What I would have asked, had we been allowed to intervene, was be,
Undoubtedly, at some point, there'll be a motion to extend the time to make a sale.
and what we're saying is the court should never have granted the second motion in the first place. And had we had notice, we would have shown up and said, the court granted it because there was no opposition. Had we been there and opposed it, the court would have said, no, I'm not giving you more time. And they would have lost their opportunity to have the foreclosure sale, and their judgment would be void. And that's what we are hoping would happen here. The fact that we are doing it years later, all the judge looked at below was all this time passed. But this court said in the, I love this name, Yuppie Puppy Pet Products case, said in examining timeliness of the motion, the court does not engage in mere mechanical measurement of time, but looks at whether there's a delay in resolution, and we're not the ones that delayed all this,
So in
or
March
whether
of
there's
20,
prejudice.
you
There's
said
no prejudice.
in March of 2022, when U.S. Bank moved to restore the foreclosure action, who was served with that?
March of 2022,
Right, that's when this foreclosure action gets restored.
we were not served with any papers until we came into the court ourselves. My client was never served by U.S. Bank with anything until we went to the bankruptcy court and challenged this, and then the bankruptcy judge said, no, come to state court.
Was Arenthal served?
I don't know.
Thank you.
May it please the court, Fiona Brown for the respondent. At issue here is first whether the lower court erred in denying the appellant's motion to intervene, and we answer in the affirmative no. Here, they're pursuant to CPLR 10.
Does it matter?
I'm sorry.
The same question. Your adversary seems to make a point that no sale had occurred, so there's not a problem with the intervention at this time. What effect does that have on your argument?
We respectfully submit that it has no effect.
Well, obviously,
There is
but
case
why?
law that says that the judgment of foreclosure and sale is final as to all issues that could have been raised in the foreclosure and have been raised. For all intents and purposes, the
So what is the status of that at this point? Does the record reflect?
that the,
You've got a judgment of foreclosure. Your adversary says there's been no sale, so
yes, there has been no sale because of the pendency of this appeal. We did not want a cloud on title, so we did not move forward with these.
Well, I mean, there's more to it than that, right? Because several years have passed.
Yes, we did obtain an extension of time to sell the property, and I would like to note that the motion in 2022 was served on the borrower who had appeared in the action. He appeared and filed.
So you mean in March of 2022 or whenever that motion was
Yes.
noticed, Arenthal had been served with,
Yes, he was served with it, and he subsequently appeared, filed bankruptcy after that motion was granted, filed a notice of COVID hardship during the COVID pendency, and his attorney
is there any
filed a
reason that
stipulation.
Sterling should have been served at that time?
At that time, I don't know if plaintiff was aware of their ownership interest at that time. I can't say whether or not they would have. And even if they were not, they weren't part of the action. They hadn't sought to move to intervene, and they were still subject to the JFS, which had been entered approximately 9 years prior to them acquiring their interest in the property.
And if so, wouldn't they step into the shoes of Arenthal? They'd be in no better place than
They would be
Arenthal.
in no better place than Mr. Arenthal at that time.
But they knew about it, or they knew about it through Arenthal?
They should have known about it based on the entry of the judgment of foreclosure and sale that would have come up on a title search during the sale of the property. And not only that, they should have known of it when Mr. Arenthal was served in 2022.
I mean, they took with either actual or constructive notice of the state of the title, which would be reflected the plaintiff's interest
Yes, the title report
or
would have,
U.S. Bank's interest.
would have reflected a judgment of foreclosure and sale, and it would have, there was this pending action from 2008, 2009.
Well, if they had an interest in the property 7 years ago, why didn't you know about them, and why weren't your papers served on them?
Honestly, I can't, I do not have the title search we probably would have had to run a title search around that time, and I'm not sure that that was done. I can't say if that was done. If there's no further questions. with us.
You did. You know, I asked and you chose not to, so we'll leave it there. Thank you very much. Thank you both. Heightman Credit Acquisition versus Meadow Partners.
May it please the court, Arnold Pacinage, Cole Shots PC on behalf of the defendant appellants. Your Honors, I want to focus on the first and primary issues on appeal because it is dispositive and it was decided incorrectly as a matter of law. And that is the trial court erred in its departure of well-established First Department law that a breach of contract without more cannot be the predicate wrong for a veil-piercing claim.
Well, didn't the court say that at least, again, this is another 3211 motion, they knocked out all the other causes of action, but the court allowed the plaintiff to replead, right, on this fifth cause of action for alter ego piercing the corporate veil, right? And wasn't there allegations that the plaintiff made that you hadn't let them know about this $2 million kicker, so they took this, property and they made this agreement without knowing a very important issue, and that could have been wrongful action that might have also been the wrong?
Yes, Your Honor, that is the allegation in the complaint.
What's wrong with that? I think that's wrong.
Your Honor, that
Could be wrong if it was true.
Absolutely. That wrongful conduct, however, is rooted in the contract. The contract specifically
The
has...
contract required you to notify them about this $2 million kicker.
The contract has representations. Yes.
So what this case is the wrong is that you breached the contract.
Correct, Your Honor. And First
So
Department
if you were to pierce the corporate veil here, it would mean every breach of contract justifies piercing the corporate veil.
Exactly, Your Honor. And this department has unequivocally said that's not the law. The department, since Skanska back in 2000.
But let me ask you something else, however. I mean, there is this other action pending relating to this $2 million fee. Why shouldn't this action have been stayed pending determination of the related action?
Your Honor,
You actually thought it should be stayed.
Absolutely, Your Honors. It should have been stayed because the related action, which was filed back in...
So what happened?
Your Honor, the trial court denied the stay.
Well, the plaintiff in this case filed the RJI in this case, right?
Yes, Your Honor.
And I looked at the RJI, and it didn't say that there are any related cases. Now, having sat in the commercial division, and, you know, at 60 Center Street, you're supposed to put down the related cases, and then the court does what the court does. So there were no related cases. I mean, Arnold and Porter should have known that, so they should be together.
Your Honor, they should be together, and this second action was filed around the time where summary judgment motions in the first action were being briefed. Since that time, there's been briefing and oral argument, and we're currently waiting a decision from Justice Bannon for the literal exact issues that are
I
at
want to
play
get
here.
back to the alter ego
Yes, Your Honor.
issue, because it seemed like, you know, this is not, might in your eyes be a regular breach of contract, but there was domination, complete domination by the company over Meadows, over 109 South LLC. And it wasn't mere domination. They, you know, had other indicia that would be supportive of piercing the corporate veil. They had the alter ego. It was, they had the shared offices, the same offices, shared personnel, same place, principal place of business. The same principals acted as officers of the subsidiary. They were fully aware of the sale contract obligations. I mean, it seemed like there was a lot more than just, this was just a breach of contract. They deliberately left without the, talking about the $2 million that was necessary. So why isn't this different than just, you know, there's something else going on here than a mere breach of contract?
Your Honor, as Your Honor recognized in the dissent of Rich versus J.A. Madison not long ago, mere domination is not enough.
This wasn't mere domination.
Your Honor, here we have sophisticated lending entity. They lent over $50 million to the borrower defendant here. The borrower defendant occupied the premise under a special purpose entity. This is sophisticated commercial.
I'm pretty sure.
It's a single-purpose entity.
I'm sorry?
It's a single-purpose entity.
Absolutely. And the contract.
I'm pretty sure in Rich, you know, Madison, I got the name wrong, but you know what I'm talking about. There was nothing about $2 million that was supposed to be paid that wasn't spoken about in the contract with with Heightman.
No, Your
So
Honor.
this is very different in that
Respectfully,
case.
Your Honor, it was worse in that case because in that case, the majority found that there were allegations that the alter ego parents.
There was nothing that was held back in that case. There was nothing near $2 million that would deliberately not spoken about, that was kept from the person who was buying the property. There is
Absolutely,
no
Your Honor.
comparison, so you might want to move on to another argument.
Your Honor, the allegation in this case stems from a representation. And that's what the trial court found when it dismissed all of the tort claims
I mean,
just 3
counsel,
months
if
earlier.
we were to just go and follow your argument to its logical conclusion, then in no breach of contract case could we ever pierce the corporate veil. But clearly there's some carve out as to allow that. Why isn't that carve out applicable here?
Your Honor, we are not asking for, nor does the court recognize a bright line rule that breach of contract can never be the predicate act. But what the cases say is there needs to be something more. As
Why
the New
wouldn't
York
there need to be discovery, given what we're hearing? Why wouldn't discovery be warranted under these circumstances to flesh that out?
Your Honor, because the allegations are conclusory, and as this court found in Skanska, which is the premier case, that was a motion to dismiss. And the court said that the allegation is you breached a contract. Just because there's domination from a parent entity does not suffice to create the extra wrong that allowed you to pierce the corporate veil. We are dealing with, and it is critical that the court understands, highly sophisticated entities. The representations that were allegedly breached were breached by the borrower. The guarantor is also a signatory to the same deed in lieu agreement.
This wasn't something that was recorded. There wouldn't have been any way for him to know about it.
Your Honor, they did know about it, and that's part of the first case. They actually did due diligence in 2017 when they lent $50 million, and the contract was provided to Heightman's counsel, Chapman and Cutler. And that's well established in discovery.
Certainly, they
in
would
the
have been
first
in a
action.
position to request the contract.
I'm sorry, Your Honor?
Certainly, if by looking at the title to the property, they would have realized that there's a contract out there that they could have asked to see that contract.
Absolutely. Again, this is a sophisticated lending entity. They entered the deed in lieu of foreclosure because they wanted the keys to a $50+ million property rather than trying to chase the debt that was owed on the property. This is not a situation where unsophisticated individuals were defrauded. Heightman understood that this was a special purpose entity. They lent to that special purpose entity.
Thank
So
you.
for these reasons, the court should reverse. Thank you.
Good afternoon. Pardon me. Eric Whitney with Arnold and Porter for Heightman.
What the dealing here is parent corporations with subsidiary corporations and these single-purpose entities where there's no expectation that other than the property that there's going to be any assets there. With parents and subsidiaries, they're frequently the same offices, the same directors, the same address. There's domination. There are no allegations here of failure to observe corporate formalities, are there?
That is alleged in the complaint, yes.
What's that?
That is alleged in the amended complaint,
What do you
yes.
say about that?
Pardon
What
me?
allegation do you make about failure to observe corporate formalities?
We believe they didn't hold board meetings and didn't have minutes and those sort of things. But again, we haven't had discovery. So, and let me just address that real quick, because I think this is a very important point. There are a few things there were a couple of misstatements just a moment ago. I'm sure they were inadvertent. That contract of sale that was never disclosed, it was not recorded. So title search would have done nothing to reveal its existence. And it wasn't produced.
As you're dealing with these entities and you're loaning $50 million, you see how the borrower, the expectant borrower has come into possession of the property. Might it not occur in doing due diligence that maybe we want to see that contract before we loan the $50 million?
Things like that were requested and not provided. The contract of sale with the kicker was
You
never
mean you
provided.
requested it and they were not provided?
you
And
can't
went
request
forward with
something
the
if you-
loan anyhow?
We asked for all the, in diligence, it's all documents relating to the borrower, its organization, contracts.
Did you get that document?
No, never.
Was that document recorded someplace?
No, it wasn't. It could have been.
But you knew you
Should
didn't
have
get.
been.
But you knew you didn't get that document.
No, we didn't know it existed until we got sued in the other case.
Well, how did they come to own the property?
They owned the property already for 5 years when we came on the scene. When they bought the property, they used a different lender. They'd already owned the property for 4 or 5 years with clean title, as far as we knew. So there was no red flag that maybe there's this kicker.
So if a breach of contract cause of action justifies piercing the corporate veil, why wouldn't every breach of contract cause of action give rise to piercing the corporate veil? What's going to be the bright line rule emerging from this case that says here you can pierce the corporate veil based on a breach of contract action, and the other breach of contract action does not give rise to piercing the corporate veil?
Sure, it's an excellent question. The answer is it won't. I wholeheartedly agree, and this court has made crystal clear in all the cases that we've cited, that a breach of contract without more does not support
But the only
piercing.
cause of
But here
action
we
that
have more.
survived here, the only cause of action that survives here is a breach of contract cause of action.
It doesn't, if you look at the cases, Your Honor, respectfully, it doesn't say that you have to have other causes of action. And if you look at the the Jonathan Adler case, that a couple of you recently, I know you wrote the opinion, Justice, and now you wrote the dissent, which I found. I think that case is squarely on point here. First, there's domination. The allegations which we've made about domination are not conclusory. They have detail. We only learned about that information in discovery in the other action, and I'll come back to why this case was filed later, because what we found at the end of discovery, the last day of discovery in the other action. That's why this case was brought separately and not in that case. But the answer is domination. I don't think that's really, subject to much dispute here, that we've adequately alleged it. Maybe in discovery, They produce a bunch of stuff, and it shows that there wasn't domination. But we get that in discovery. The second prong, though, is the more. And what Justice Crane was crystal clear about is that there is more here. And it doesn't require, Your Honor, that there be more causes of action than a breach of
But
contract.
does it have to be more than the failure to disclose that kickback, which is part of the contract representation anyway?
It's part of it, but right, you can have, the more that we're alleging is not just you breached this warranty. That's the breach of contract, admittedly. That the more is the active concealment of this contract over the course of 2 transactions. The entering into the deed in lieu, actively concealing, and the deed in lieu, by the way, was wholly negotiated by the Meadow entities. The one-on-one property has no employees.
The
or-
concealment doesn't give rise to more than just a breach of contract. Duty to turn it
well,
over.
we tried that.
The duty to turn it over arose only because it was in the contract.
I'm sorry, I didn't
The
hear.
duty to turn over that contract is only because there was a representation in the contract.
Yes, they should have turned it over, and they should have disclosed it, but they actively concealed it. And so the more here is that active concealment. It's also the
act of
hoisting
concealment,
the
which is
$2 million
no more-
obligation.
which is no more than a breach of contract.
Well, we respectfully disagree, Your Honor, and Justice Crane disagreed with that as well, and we think that she got it right. At minimum, we should be able to do discovery into that concealment.
Why
into
shouldn't
those
this
facts.
action be stayed pending the resolution of the other action?
Because there are not an identity of parties or claims. There are parties in the plaintiff in the other case is not in this case.
Why wasn't it joined with the other case?
I don't know why it wasn't joined. At the point in time when we learned in discovery of this alter ego things, it was at the end of discovery. It was too late for us to amend our counterclaims or even to bring in these Meadow entities. So that's why we brought it as a new.
Why didn't you put on the RJI that there was a related case pending?
We didn't view it as related because you have different parties.
These cases aren't related?
I mean, they're somewhat related, but I don't know why that wasn't put on the RGI. But the fact of the matter was,
The resolution of the other case doesn't have the possibility of mooting all or a large part of this case?
no, in fact, it likely we're going to get a decision on the summary judgment motions, and it will answer one of the foundational questions in this case, which is, was there a breach of contract for failing to disclose?
So shouldn't we wait till we see what happens there?
Yeah.
No, but there's, I'd say, no chance that it takes longer. We can do discovery in this case and wait for the
Isn't
decision.
some
in
of
that
the
case.
discovery here duplicative of what happened there?
It overlaps, but there's additional, because of the alter ego allegations. We get discovery, and Justice Crane has ruled in our favor on this, that we're entitled to some additional discovery from these Meadow entities about what they had.
If the summary judgment comes out and says there is no breach of contract, what does that do to this case?
It probably ends it. I think that's highly unlikely, but to be honest, yeah, I mean, it probably does.
So there's a distinct possibility that the other case moots this case. I know you think it's unlikely, but it's definitely a possibility.
It's possible, yes, of course.
Thank you.
Thank you.
Thank you, Your Honors. Just briefly, the record is really undisputed that in 2017, Chapman and Cutler, as counsel for Heightman, received this information. There's emails about it, and in fact, during summary judgment argument in the Szer action, the first filed action, there was an entire discussion with Justice Bannon about that particular issue, because it is a primary defense in that underlying action that Heightman knew about and assumed this obligation through our own due diligence. The only other thing I want to address is the Rich case. And as Your Honor said in the decision, there were 3 primary pieces of evidence in that case that permitted veil piercing that don't exist here. The corporate entity stopped making payments under the agreement, in addition to causing the entity to become judgment proof and dissolving the entity during the pendency of the litigation. None of those allegations exist here, Your Honor, which distinguishes you.
And in fact, here, the entity is expected to be without assets because it's a single-purpose entity.
Exactly, which Heightman always knew, Your Honor. Thank you.
Thank you both. Aurelius Capital versus Hertz International. Thank you.
Your Honor, may it please the court. This appeal presents two distinct questions, each of which provides sufficient independent basis to reverse the decision of the trial court. I'd like to start with the first. The first question is whether the trial court erred in determining that the plain language of a contractual provision that triggered the plaintiff's right to payment if the defendants raised or committed to raise alternative financing.
Counsel,
Yes, Your Honor.
commit or committed to raise wasn't further defined in the contract, right?
That's correct, and that's why, obviously, the court and the parties had to do some work to try to determine what the phrase commits to raise mean. And what we would submit to this court is the trial court's determination that the word commit in the phrase commits to raise means to pursue. That's what the court said, and I would argue the court used it synonymously with to consider, is not a correct
You
reading.
would use a dictionary definition?
So
What
a number of-
definition would you use?
Yes, Your Honor. So there's really 4 points we would like to make as to why the court erred in equating commit with pursue. First, yes, we started with a dictionary because Your Honor is correct. If the contract gave us a definition, we would have started with that. It did not. All of the definitions, and we provided in the briefing a number of ours, the plaintiffs or the appellees provided theirs to the court, and I'll include theirs in this. All of those definitions have one thing in common that is flatly inconsistent with commit equals pursue, and that is commit must have an aspect of bindingness or definitiveness. There is a difference between committing to something and considering something. And we
You
would
commit to something, then that comes along with it that there's going to be some kind of consequence if that commitment falls through. Why is that different than what happened here?
So, Your Honor, I actually think, I don't know that I disagree with you, because what we submitted is that to commit requires an obligation, to undertake an obligation.
So it had to be, the final plans had to be signed, sealed, and delivered in order to be commit? Is there any other in-between place that it could have been without having the final document, which was signed a couple days later?
So I think not, Your Honor. And I think in addition to the dictionary definition, we do have guidance from this court and my colleague will say I'm changing the word. I would suggest I disagree with that, but there are cases that talk about a commitment and what a commitment means. We would submit that those words are highly related because to commit to something creates a commitment. And the law in this department is that a commitment requires a legally binding obligation. And the case that we cite in our briefs makes clear that considering something or pursuing something or working towards something is not a commitment. An additional point.
But there were so many emails back and forth during those last few days about finalizing the loan from the other parties. Why wasn't that they commit to doing it?
So to answer Your Honor's question.
Other than not being signed, and I'm not,
Well, it's more than just not being signed, to be clear. So let's talk about what actually was happening in those last days. Herz had identified 2 different possible plan sponsors to resolve the whole bankruptcy.
Right.
Okay? And it was working with both of those. So there wasn't even a definitive counterparty at the time these filings were made with the bankruptcy court, which led the parties to terminate. So it's not the case that it was, okay, this deal is done, we just haven't signed it yet. Herz hadn't even decided which of the 2, if either. I mean, I won't bore the court with the whole history of the case.
But you had lined up financing before the March 30th day.
So we had
How
arranged.
does that tie into this whole consideration of the commitment issue?
So Your Honor, I would respectfully submit it is not a commitment. There are other types of contractual provisions, including one in the related contract that we pointed to, where you can prohibit or provide a remedy if you negotiate, if you solicit. There are all sorts of.
So am I understanding this correctly? If the financing comes on April 1st, you get out of paying the fee. Is that right?
So that's correct, Your Honor. This was a lockup, right?
So if on April 1st you get the money from someplace else, the plaintiffs are not getting that breakup fee, right?
That's correct. This was a high.
So does this contract made, is that a commercially reasonable interpretation of this contract to say that this was all placed into the hands of the defendants? We're going to bring home the money we need to keep our operations in Europe going. We're going to bring it home on April 1st and thereby get out of paying the breakup fee to the plaintiffs.
So, Your Honor, I think we want to take that in pieces. First of all, this was a very specific contractual provision that locked our clients up from doing a very specific thing for a very specified period of time. Now, if what Your Honor's question is implying is, if Hertz did something to unduly delay, could there, if it breached the contract, could there be other contractual remedies that might result if Hertz acted in bad faith?
It doesn't have to breach the contract, it just can be slow. We're not going to sign this till April 1st.
And the deal was, because remember, April 1st or March 31st was the backstop date. That was the absolute deadline.
And then, yeah, so I know maybe you'll get to this, but the 31st was the absolute deadline, but it was terminated on the 30th. Is there significance to the fact that it was terminated on the 30th?
I don't think so, Your Honor. The plaintiff terminated it on the 30th. It would have expired on its terms in the next day. In no circumstances, and this gets to the second point.
So what you're saying is it would have, in any case, it would have expired before the opportunity for Hertz to have gotten the new.
Absolutely correct.
The new.
Yes.
So maybe you're turning to it, but I wanted to ask you, assuming definitely without saying that that's so, if we disagreed with you on this first point about commitment, is there a way that you prevail anyhow?
Yes, Your Honor.
The fact that this deal couldn't be done because you couldn't get the bifurcation order, because you couldn't get the United Kingdom scheme, without the bifurcation order, you couldn't get the scheme out of the court in the United Kingdom. So the deal, that loan could not have been made as originally agreed. Does that get you to prevail anyhow?
The answer is yes. I'd ask, may I have permission to
Yes.
provide? Okay. I will be succinct, but absolutely, and that's where I started. There are two independent bases. The exception would apply even if the court found alternative financing were secured during the applicable period. The exception was negotiated for to cover that circumstance. And here, the error that we would respectfully submit the trial court made is by kind of taking plaintiff's suggestion that we just talk about Hertz, it ignored the fact that the defendants, who are the ones on the hook for this fee, were not parties to the bankruptcy and had no ability to secure that bifurcation order. And this exception, which again is only one part of a larger deal, there might be other remedies, they could sue other people for other things, but this exception was clear. If the defendants could not consummate the deal through no fault of theirs, then the fee was not owed, and that was exactly to address this type of situation.
And that there was no fault of the defendants, at least that's your position, in the failure to consummate what needed to be done in order to carry out the agreement as it had been made.
Yes, the undisputed record, there was no factual dispute, was everyone acknowledged the defendants who are not parties to the bankruptcy and have no control over their parent had no ability or obligation to get that bifurcation order. I thank the court.
May it please the court, Dwayne Loft on behalf of the plaintiffs.
I want to ask you about the second point. There is no question that the bifurcation order wasn't obtained, and I know your brief complains about the fact that they delayed it, but the reason it was getting delayed is because the creditors in the United States wanted no part of the bifurcation order. So it was put off and put off for that reason. They couldn't get the bifurcation order. You can't get the bifurcation order. You can't get the scheme order out of the United Kingdom. The deal can't be done as negotiated. that's not the fault of the defendants, why doesn't that let them out of having to pay the breakup fee?
For two reasons, Your Honor, one factual and one legal. The factual issue is that, as the court found, we don't know whether or not the U.S. Chapter 11 entities could have obtained the bifurcation order. They didn't prosecute it to a court hearing.
Didn't the United States creditors unanimously oppose the bifurcation order?
The U.S. trustee is the only one that actually filed a motion in opposition. There were other
Because all the creditors were opposing it.
The other creditors, out of their own self-interest, because they were proposing rival financing, they sent draft pleadings to try to persuade the debtors.
But you couldn't do the deal without that bifurcation order, because if you did, that would drag in the European entities into the American bankruptcy.
2 points there, Your Honor. First of all, Hertz made a business decision, as the court found, in the U.S. to abandon bifurcation, not prosecute it to a court hearing, because it found another way to do the European financing that concerns these defendants without bifurcation. But by keeping
Isn't it true that a bifurcation order had never been done before in bankruptcy court?
That's correct, Your Honor. That's correct, Your Honor. But we still don't know, and the court found we'll never know, whether it was possible or not. And ultimately, as the court found, the test is possibility. That's what the words say on the page. The second point legally, Your Honor, is that the fault of the defendants, which is the theme you heard from the defendants, does not matter. The contract does not say if a condition could no longer be satisfied due to the fault of these defendants. The agreement simply says a condition could no longer be satisfied, full stop. Regardless of whose responsibility it was, regardless of whose fault it was. Fault is not an issue. So when the defendants say it's unfair to apply this condition when it was not the defendant's fault that it failed to occur, that has no meaning legally. And that's the way the court interpreted this, as an impossibility condition. That's the way it reads, and that's the way the court interpreted it.
I want to see that I'm clear about this. If the loan couldn't have been done the way it had been agreed to because of these bankruptcy issues, don't the defendants prevail?
They do not, Your Honor. And that's because we don't know factually, and we'll never know factually, whether the bifurcation order could or could not be possible. Because as a business choice, it was abandoned. So the actual factual predicate to test possibility never arose. And
By the time it was abandoned, wasn't it impossible to do the deal as it had been originally expected because there wasn't enough time to get the order from the United Kingdom court?
This is a critical point, Your Honor. In order for the impossibility exception to apply, there has to be two things that are true. One, there has to be a failure of condition, here the bifurcation order. Second, that condition has to result in the scheme transaction no longer being possible. It's not the deal. The scheme transaction has a very specific meaning in the contracts. The scheme transaction is...
So wasn't it impossible to do the scheme transaction within the required time frame because you didn't have the bifurcation order?
It wasn't, Your Honor, because the scheme transaction is defined to be a transaction pursuant to which the restructuring or any part thereof is implemented by way of one or more English law schemes of arrangement. So the definition of the schemes transaction is not specific to the exact deal that included bifurcation. If other parts of the restructuring were capable of being implemented through one or more English schemes of arrangement, then the scheme transaction, as it's used in these agreements, remained possible, which means that the defendants have no benefit from the exception. And under the facts here, all of the other parts of the restructuring, besides bifurcation, remained eminently possible all the way throughout termination. And in fact, this became clear as of the 2nd of March in a disclosure statement that the Hertz U.S. debtors filed with the court, where they said, we're prepared to move forward with a scheme of arrangement as modified to replace the conditionality related to the entry of the bifurcation. In other words, they're representing to the court that they're ready to proceed with the scheme of arrangement, just without bifurcation. And that exactly matches the definition of the scheme transaction as any part of the restructuring implemented through one or more English schemes of arrangement. And if that definition holds, there's no exception. And again, there are two elements of the exception. First, there has to be the failure of the bifurcation order, and then that has to result in this scheme transaction being possible. The defendants had a burden to prevail under both, and they fail on both. But even if they succeed on one and fail on the other, they still lose the exception. That's critical. Now, if I may be heard quickly on commits to raise, the defendant's argument, Your Honor, just starts from a false premise. The premise is that the trial court defined commits to raise to means merely pursue, and that simply was not the trial court's definition. The trial court did two things. The first, which was most important, is that the court defined commits to raise to not require a legal obligation. That was the most critical aspects of the court's ruling. And then the court went on, having ruled that it does not require a legal obligation, found that in this context, commits to raise means, in the colloquial sense, committing to pursuing alternative finance. That's not just pursue.
Committing and pursuing in themselves have two different definitions.
Exactly, Your Honor. What defendants are leaving out is the word commit. They want commit to just mean pursue and then attack the trial court ruling. But that's not fair, because the court actually preserved meaning for the word commit. That couldn't be clearer in the paragraph that immediately precedes what I just read to Your Honors, where the court said the choice to pursue and materially agree obligated the defendants to pay. So the court there is elaborating on the definition of commitment. It is not just pursue, it is pursue and materially agree. And she found correctly on the evidence here that the defendants had materially agreed to every relevant aspect of the alternative financing at the time of termination. Now, just last, Your Honors, defendant faults the court for not using a dictionary. The defendants did not offer the court a dictionary. In fact, the defendants' definitions from their dictionaries do not surface until their reply brief before this court. The defendant can hardly fault Justice Schechter for not accepting their dictionary definition when the defendant did not proffer a dictionary definition. The defendants instead relied on custom and usage, period. And the court rejected that, the court properly rejected that, and they have not pursued that issue on appeal. Thank you.
Fairly quickly, I'm going to try and make 3 points. First, on commits to raise, the trial court's finding that no legal requirement is the nature of the error that we identified. But I want to make one other point. Mr. Loft says materially agreed. There was not even an agreement as to who the counterparty was at the time that the agreement expired. So to say this was not the case, I actually believe you would not meet the definition of commit if everything was done but the final step, but that wasn't even the case here. Here, you had two competing proposals. The company hadn't even decided which of which to pursue. So this is not the case where all that we needed to do was sign the paper, and I think that's extremely important. Second, on the second piece, the application of the exception. I just want to be clear, and I actually don't know if I'm even helping myself on this to the court. The reason, just the two European defendants, not, look, on the argument that you heard here today, and that was a mistake, this exception only applies not if this scheme transaction could not occur, because it's undisputed that this scheme transaction could not occur without bifurcation. Their expert agreed to that as she had to. The court found that for it to apply, no scheme transaction would be possible, and that reads the exception out of existence. I thank the court for its time.
Thank you. Thank you both. Hubbard versus Apple Square.
May it please the court?
Just a moment, please.
Of course. May it please the court, appellant appeals two portions of the lower court
Could you put the
decision.
mic closer to you so I can hear you better?
Yes, of course. Is that
Thank
better?
you.
Is that better? Okay. Appellant appeals two portions of the lower court decision of Judge Hummel. The first portion, the lower court granted conditional summary judgment to respondent Chase on its third-party claims for contractual indemnification against the appellant. And the second portion appealed from is the lower court denied appellant's motion for summary judgment. Appellant performed facility management services on the location of this trip and fall incident pursuant to its contract with respondent Chase. However, there is no evidence that appellant had sole control of the premises or that it contracted with a third-party vendor to perform any repavement work in the parking lot, which is what the lower court stated in its decision and order. There is no, there's no evidence.
The question here, I think, is whether or not Chase should be granted a conditional summary judgment on the contractual indemnification. At least that's one of the issues.
Yes, that is one of the issues.
And there was still, it would seem that Chase still bore responsibility for whatever negligence. They still had responsibility to ensure that there was no, that they were not negligent in the care of that parking lot.
Absolutely. So Chase had numerous employees stationed at the bank. It was a bank operating fully until a couple of months before
Right,
this
right. So it was
accident.
abandoned, the building was abandoned, the lot was abandoned, but they were still responsible for.
They were still
its
responsible. They were also moving
condition.
furniture and equipment out of the bank, which could have caused this alleged metal object to end up in the parking lot. And they also, according to the contract with appellant, had the ability to retain third-party vendors to perform services in the parking lot. There is no evidence that appellant performed any services in the parking lot, any repavement, any speed bump work before this accident date.
Didn't you
No
have
evidence.
any responsibility to inspect it periodically? I mean, you still-
Absolutely. Absolutely. Appellant does not deny that it performed facility management services. Appellant witness testified that the appellant would go every 4 months to inspect the property, and according to the last inspection, which was January 2018, almost 4 months before the accident date, there's no documentation that there was any metal object in the parking lot. So appellant had no notice of this condition in the parking lot. There's no evidence
What
that
kind of
appellant-
maintenance was your company, your client, responsible for?
Appellant was responsible for maintaining any issue that arose if there
In
was.
the parking lot, or anyplace else?
Correct. Appellant, if
So then,
they
if that
saw-
was there and they didn't take care of it, would be their responsibility as well?
Yes, and if there were work orders, like a work order put in saying, hey, to appellant, do this work, there's an issue, there's a defect, there's a metal object, and then appellant didn't do it, then appellant would be responsible.
Well,
and-
they didn't only have to do it because Chase alerted them to it. They were supposed to inspect it themselves. so they
Absolutely.
might-
They went every 4 months to do the inspection.
4 months, to me, sounds like a long time. I mean, an entire winter season could go by. I mean,
I agree.
Is that reasonable?
But
Is that?
I agree with that, but that is what respondent Chase wanted appellant to do.
That's what they contracted to? There's a
Exactly.
contract that
That's
says
what the
4 months?
contract states, that they're supposed to go periodically, once every 4 months, to inspect the property and take care
And
of
that's
any
in the
condition.
contract of once every 4 months?
That is not specifically in the contract. What the contract says is, because this contract lasted for years and goes for many,
Says
many different
periodically.
branches, that it's periodic and it's what respondent Chase wants. And I can tell you from my
So
experience.
where do
with-
we find that 4 months is the time period, is that what?
Because the witness testified that that's how often he went to the bank.
That's
because-
different than,
Their responsibility.
So so the reason, the reason that he went once every 4 months is because the witness would be prompted in the electronic work order system, by the end of this month, you have to go to this location among many others and do the inspection by the end of the month. So he went according to what he was told to do, and the frequency that he was told to go was determined by Chase as to what
so it's
respondent
more of
Chase
a
wanted
on
to pay.
request?
Well, it was an automatic work order that went to the appellant, requiring them to do this inspection. And at the time, 2018, it was once every 4 months for
For
Was
this
there
bank,
any-
for every bank.
Was there any mention of this alleged condition in any of these reports?
No mention of this alleged condition in any work. There was no work order about parking lot work. There's no invoice. There's no purchase order. We looked very
Who
thoroughly.
removed the speed bump?
What was that?
Who removed the speed bump?
So there is argument by respondent Chase that there was a speed bump and it was removed and there was a metal object that remained
Right, who
as a
removed the
result.
speed bump?
We do not know who who removed a speed bump.
Okay.
There are Google Map images that show a speed bump was there, and then there are Google Map images
Thank you.
shows.
You have some rebuttal. Thank you. You have some rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Guy DeRosier, Wilson Elser for Respondent J.P. Morgan Chase. Just addressing this general point that essentially JLL is saying you can't prove that we did it. It's not for want of asking questions. There was questioning. There was a post, I believe when we deposed the witness from JLL and was asked whether any work had been done, whatever, the answer we got was, I don't know. We sent out post-EBT demands. One of them, which appears on page 596, which is paragraph 13 of our demand, said copies of any invoices and estimates from any third-party vendor hired or used by JLL who performed repaving or repair work at the parking lot for the 2-year period up to the date of the loss.
But why are you entitled to summary judgment now against Jones Lang on indemnification?
Well, we're only seeking conditional indemnification, and the reason why we're seeking conditional indemnification is because there are issues of fact as to whether JLL was negligent, and there are open issues of fact also whether JP Morgan may bear some responsibility for this accident. I think the case law from
Why should you get any indemnification at this point?
Well, there's the case law that we cite from this department on pages 8 and 9 of our brief are very clear that this court does provide conditional summary judgment that's subject to an apportionment of liability if the contract is very clear that we would be entitled.
But isn't it possible when this is all done and finished that Chase is found to be perhaps solely liable for this?
I don't think the
I'm
evidence.
not telling you that it's likely, but it's a possibility, isn't it? And wouldn't that militate against giving you any indemnification at this point?
If there's a finding
You
at
can
the
hear
end
the
of
point
day,
even if you don't like hearing it.
Sorry?
I said you can hear the point even if you don't like hearing it.
It's nothing is impossible, but I
mean,
think.
for example, she's saying that it's 4 months, that was sort of the general agreement, that it was 4 months. If in fact, in discovery or whatever, it comes along that it's 4 months, and they look at it in January, and then they don't look at it again until the end of April, and someone says, you know what, this thing wasn't there in January or February, it only came up the beginning of March.
Well, it's more than that. This is not a transient condition. These were bolts that were embedded in the asphalt, and they happen to be exactly at the location where a speed bump used to be. Now, we asked questions about the speed bump. We never got any response from JLL to our specific
Chase
request.
doesn't know who removed the speed bump.
No, but we have proof from our own witness, the affirmation of Kathleen Pendergraft, that no one other than JLL was performing facilities maintenance functions for Chase during the entire period. So if anyone removed the speed bump here, it wasn't Chase. It would have been either JLL or someone hired.
They hired.
Right, and under the MSA, the definition of personnel includes any subcontractors that would have been. So the indemnification obligation is triggered only by if either JLL was negligent or one of its subcontractors was negligent. It's clear that we're entitled to indemnification.
So what do you have to prove in order to get conditional summary judgment at this stage on the contractual indemnification? That you were not actively negligent, that you were free from negligence? What do you have to prove?
This is actually a very interesting question. I did a lot of research on this, and
Because I did too.
Yes, there is a split between the first and the second department on this. There's a lot of case law from the first department, and we're very happy with that one. We're not asking you to adopt the second department rule that said there's no need for the person requesting indemnification to prove the absence of negligence in order to obtain, again, conditional summary judgment. We're not asking for unconditional. Clearly, we'd have to prove either that Levine versus Shell Oil applies and we're entitled to indemnification even against our own negligence, which was the case in the Rubio case against JLL, which we cited in our brief, or if indemnification is otherwise limited either by the terms of the indemnification clause or by statute, then we're entitled to partial indemnification, so we don't have to prove that we were not negligent. We just don't have to prove that the trigger, in other words, if there's a finding of negligence at the end of the day, we're entitled to indemnification. We don't have to litigate whether or not the indemnification clause was triggered. Unless the court has any further questions, I'm happy to stand on our brief.
Thank you.
So the First Department has decided on this issue of conditional summary judgment, and the First Department has held that if there's issue of fact as to proximate cause, then conditional summary judgment is not granted.
So what case are you talking about?
Callan versus Structure Tone, Jaminder versus Uniondale Union Free School District, Korea versus Professional Data Management. They're in my brief. And the First Department has also found that when there's a question as to whether the defendant is negligent, defendant meaning respondent Chase in this case, conditional summary judgment is denied. And that is Corrales versus Rexon Associates Realty, Marmo versus Mall Properties Incorporated, again, also in my brief. And I just also want to reiterate that JLL was a facility management company, but according to the master service agreement, respondent Chase had the ability to hire their own third-party vendors to do any work they wanted on the property, and that is also in my brief. So it is completely possible that respondent Chase hired someone to remove a speed bump, to do parking lot work, to do anything, because JLL did not come up with any work that was done. Respondent Chase also was not able to show that appellant JLL did any work.
And all discovery has been done here.
All discovery has been done.
Summary judgment motions.
Yes, we looked very hard for a work order because that would, of course, allow for certain conclusions to be made, but there's clearly issue of fact as to who was negligent between us and respondent Chase. There's certainly question of fact as to whether respondent Chase, who had numerous employees there, who moved equipment.
We understand the point. Thank you very much.
Thank you very much.
Thank you both. People versus James Martinez. Did I miss something? Oh, I'm sorry. People versus Abubakar Musa.
Good afternoon. May it please the court. Jane Merrill for Mr. Musa. This case presents precisely the question that the Court of Appeals left open in Spicola, whether expert testimony is admissible to rehabilitate a complainant's credibility when the defense's attack centers on recantation rather than delayed disclosure. The Spicola court noted that in that case, defense counsel disputed the scientific reliability of CSAAS, quoting from an article by critics of that theory. But the court noted that the quoted passage did not question the empirical basis for delayed reporting. Rather, the authors of that article had, quote, reservations about the prevalence of denial and recantation, aspects of CSAAS that were not at issue in that case. They are at issue in this case, recantation is.
But even in Spicola, it does say that the evidence of psychological syndromes affecting certain crime victims are admissible for the purpose of explaining behavior that might be puzzling to a jury. And the Court of Appeals has repeatedly permitted this kind of testimony in cases.
Yes, Your Honor, it has. In those cases, delayed disclosure is specifically the aspect of that psychological testimony that's at issue. So this theory, CSAAS, is really not a monolith, even though the opinions reference it as a whole. I think Spicola makes clear that it really should be considered in its component parts. In that case, the defense centered on attacking the complainant's credibility regarding the delayed disclosure. So that was really the aspect that was in question there, and that there was any reason for the court to deal with. That's just not the case here. The evidence on delayed disclosure looks very different than the data on recantation. Dr. Meltzer testified that a child's recantation of an allegation of sexual abuse is, quote, not a rare thing. But the data here really tells us exactly the opposite that was cited in defense counsel's motion, and that is that recantation may in fact be vanishingly rare, far from occurring in the 15, 20, or 25% of cases that Dr. Meltzer guesstimated. One 2020 study found one single participant out of 94 who,
Why are we looking at this as a more general thing that the expert testimony is admissible to address counterintuitive behaviors? Should we be parsing it down so specific the way you are?
Absolutely, and I think this Spicola decision gets at that, and from the passage that I quoted, and I know that it's from out of...
Wasn't she using her own experience, having worked in this area for so many years, and testifying also?
She was. It was really a mix of personal experience and review of the data. I think there was quite a lot of it that was based on personal experience. Specifically as to recantation, she cites the literature and says that she doesn't know exactly where it landed, 15, 20, or 25% according to her review of the literature. That literature has been called into question, if not discredited. There's much more updated literature that really spans anywhere from 1% in a 2020 study to 27%. And that's really just not the sort of reliability that we need to admit this sort of expert testimony and to put it in front of the jury. That's the difference between this being exceedingly rare and really giving the jury to see this as a rare facet of the complainant's testimony, and something that's part of a well-recognized pattern at 15, 20, or 25%. I do think there's reason to break this down into the component parts, and I don't think that the Court of Appeals jurisprudence, or even this court's jurisprudence, has gotten at that, in part because recantation is so rare. I have not been able to find any cases that specifically address this question of whether recantation data.
Again, it's just part, why isn't it just part of the behaviors exhibited by abuse victims, right? Not just necessarily child abuse victims, we can, extrapolate that to other types of abuse as well, right? Where it's a symptom of the trauma.
My point is exactly that was at one time thought to be true, that recantation occurs in the majority of cases, and that's no longer generally accepted in the scientific community.
How does credibility of how does the credibility weigh into that? The credibility of the witness, the victim?
That was the heart of the case. The fact of admitting this testimony about recantation in particular, if not the other aspects of CSAAS, was incredibly damning and really neutered Mr. Musa's primary defense, which really you can follow the thread from the prosecution's voir dire through closing, the defense to that recantation was the reason to call this complainant's testimony into question, and this complainant's testimony and specifically her credibility. So the harm really comes from the fact that credibility was at issue here.
Thank you.
May it please the court, Sheila O'Shea for the people.
So how do you read Spicola and then cases from this court, such as Felix and that progeny? How do you read that when we're talking about recantation in particular?
Well, may I ask I'd like to make a more general point first, if the court doesn't mind, which is that all of this is really beside the point, because Nicholson controls the outcome of this case, as this court recognized in Felix. We're relying on Spicola. It found that the motion court properly denied the defendant's request for a FRI hearing on the expert testimony at issue here. So all of these arguments made by my adversary are more appropriately made in the Court of Appeals. This, with due respect, this court does not have the authority to overrule Nicholson. So that's really the beginning and the end of it. And your question with respect to recantation, I guess I would like to also.
I'm sorry, can you refresh me? Did Nicholson involve recantation?
It did not, no, but it says.
So I think the point is not that, yes, Nicholson says, that educational expert testimony regarding the CSAAS and the CSAS is admissible to explain this sort of counterintuitive behavior. But what about the recantation? That's what she's saying that's so different. It's one thing to have someone testify about a child who's testifying about their abuse and the way they testify and such.
Right.
But she's saying that this child recanted, and it's very rare, and that is different.
Well, I think, as Your Honor indicated earlier, I wouldn't parse it that finely. I don't think the courts have parsed it that finely in terms of breaking down the various components.
Well, they haven't, because it's not a common occurrence. So her point is, well, that for general matters, because generally that's not the case. You're just talking about a child who's been not just, but you're talking about a child who's been sexually abused. But in this rare case where there's a recantation, it's so unusual, saying, should this expert be able to speak about just the general?
Well, she spoke, again, she did speak in very general terms. She had not interviewed the witness. She did not weigh in on the witness's credibility. She did not know about the facts of the case, so she was just speaking generally. And I think what she said about recantation is that it's not. I think she couldn't assign a specific percentage to the number of cases in which it occurs. I think she said simply that it does happen, and sometimes children who've recanted then go back to retract that recantation. So I don't. And in terms of, again, she didn't weigh in on the victim's credibility, so I don't see how that testimony could have been prejudicial.
In this case, was there a lot of evidence apart from the victim's testimony?
A tremendous amount of corroboration here. I mean, first of all, the victim herself was very credible. She had no motive to lie. The testimony established she had a good relationship with the defendant. He never disciplined her. They'd never been seen fighting. The nature and the graphic nature of her testimony, I think, spoke to the reliability of her statements. She was corroborated extensively. The mother, the brother, the doctor, her school teachers, the doctor who examined her at Bellevue. The mother and the brother both said that when they all came home from the hospital that night, the victim said, yes, the defendant had sexually assaulted her.
The mother once almost caught him in the act, didn't she?
That's right, and thank you for reminding me of that. And one might think it's troubling that she didn't step in and intercede, but she did come home and find that he seemed to be on top of the victim and then kind of pushed her away when the mother got home, and the mother asked what was going on, and I think the defendant laughed it off, and the victim said nothing, but the mother said she thought it was odd, but she didn't see any sexual conduct occurring.
She didn't do anything about it.
She didn't do anything about it.
Did he delete a photograph that was incriminating?
Pardon me?
Did he delete a photograph?
He did indeed.
That was incriminating?
There's a photograph of the defendant bare-chested next to the victim who's smiling. She seems to be holding a cloth up against her chest. She may have it seems like she has a spaghetti strap over her shoulder, but it's again, why he deleted that, I believe, the day after the victim made her disclosure. So it suggests that he believed the image was incriminating. He had many other pictures of the victim on his phone, and he did not delete any of those. So the court is certainly welcome. I'd be happy to send up the photograph if the court would like to see it. Would your honors like me to address any of the other points, the discovery point or the way?
I don't think so. Thank
you.
you.
Thank you.
A few points, Your Honor. First, my adversary is correct that a number of witnesses testified, and in some aspects, the complainant's account was corroborated, but in some critical aspects, it was not. There was a medical examination that was done just a few days after the most recently reported incident that essentially showed nothing that could be definitively called evidence of sexual abuse. And there was DNA testing that
Well,
was
there doesn't
done.
have to be, vaginal penetration for there to be evidence
That's
of sexual
correct.
abuse.
That's correct. All of which is to say, the evidence here was not overwhelming. Dr. Meltzer's testimony was incredibly important to convicting Mr. Musa. This court does not need to overrule Nicholson. That case was actually quite limited in scope. It did deal with delayed disclosure and not recantation. And in fact, it was even narrower than that. In that case, the question was whether the jurors' answers in voir dire showed that this was within the ken of jurors such that expert testimony was not required. That's not the question here. That court relied on Spicola, which is the last court to really address this in a more fulsome way. And I think it is important to parse this into its component parts, because that's what the test demands. The Court of Appeals has been very clear that this test about whether such testimony is admissible depends on the facts of the case and depends on the kind of testimony that was given. Many components of the psychological testimony are just not at issue here. Dr. Meltzer testified that an abuser is frequently a parent. There was no question of identity here. We don't need to address that part of the psychology. What was at issue here was the recantation, and it is important to nail down whether the data that Dr. Meltzer cited was correct and was appropriate for the jury to give weight in that way, or rather whether this was in fact very rare and should never have come in front of the jury. Thank you.
Did you, Judge O'Neill, did you get to ask the question you wanted? Okay,
Thank you.
Thank you both. WPC Bill, I'm sorry, that was Blount versus Charter Communications.
Good afternoon, Your Honor. Charles Krynas for Appellant Charter Communications. Charter appeals from this action in which it was added as a defendant in an amended summons and complaint in response to a motion by the plaintiff, actually a cross motion
So
by
under the circumstances, how did the judge abuse its discretion in granting this interest of justice
I think we
application?
get that from the judge's decision. The judge in the decision goes through some criteria in determining whether the interest of justice standard should apply. The judge determined that no good cause was shown by the plaintiff to extend the time for service. The court below determined that the plaintiff failed to show diligent efforts to make service, that they were only...
But there is a distinction between good cause and interest of justice, isn't there?
Most definitely. But I wouldn't say that the interest of justice requires no standards. And the court below started to go through those things as I was enunciating, that there were not diligent efforts for service, and there was, that the plaintiff did not timely seek approval to serve amended pleadings. There's one thing that the court below latches onto to support the interest of justice standard, which is that the statute of limitations had expired as of the time I made my motion and the plaintiff made the cross motion. Well, that's a little bit exasperating for a defendant to hear. First of all, statutes of limitations are created, I believe, by the legislature to protect defendants who are no longer able to investigate stale claims. Witnesses are gone.
You knew about this, Charter knew about this. Their insurance company was on it within a week or so of this whole thing. I think by September 18th, less than a week after plaintiff filed the original pleading. So they had every opportunity to investigate. I think that's one of the reasons that the court did give the interest of justice.
Your Honor is referring to a letter that is very, very curious, that is part of the record. It's unsigned letter on stationery, assuming we understand its authenticity, from a company called ESIS. It's dated at a time that is before the amended pleadings were filed. And why is that important? Because the plaintiff acknowledges, there's no dispute in this case, that the original summons and complaint did not name any legal entity and was never served.
But it named Spectrum.
I'm sorry?
But it named Spectrum, didn't it?
It did name Spectrum, and there's certain conclusions that just shouldn't be fairly suggested there.
But Spectrum is really Charter, is it not?
Well, first of all, the original summons, yes and no. The original summons and complaint.
But this goes to what you're sort of suggesting about that letter, because the letter, the reason that letter makes sense is because Spectrum was named.
The name Spectrum is there, and excuse me, but if we look in NICEF and we do a word search for Spectrum, I think the court would find that, and don't hold me to this
It's a big
percentage.
problem.
I'm sorry?
It's a big problem.
Yes, 80 of the, and I'm picking a number out of thin air.
Yeah.
But 80% of the cases that use the Spectrum name are not my client. They have nothing to do with my client. So having a pleading that says Spectrum does not put my client on notice of anything.
Were you prejudiced? Could you tell us how you're prejudiced by this?
Oh, absolutely. We have a case we're defending now because our motion was denied, where we have no witnesses, no photos. The situation doesn't exist anymore to investigate. This case is going to come down to what plaintiff's investigator saw and the plaintiff's testimony about what happened. In addition to the fact that I was going through the criteria before, Charter Communications is not the correct party to this action. The plaintiff kind of knew this by using the Spectrum name. There's a Spectrum entity that the plaintiff should have sued. Charter, and I know you're saying Charter and Spectrum are similar, because Charter Communications Inc. is a grandparent, a step-uncle, whatever you want to call it. It's related to the Spectrum entity. But there's no merit to a claim against the parent entity that's based in St. Louis.
You have some rebuttal.
I'm sorry?
You have some rebuttal. You can
Thank you, Your
continue
Honor.
then. Thank you.
Good afternoon, Your Honors. May it please the court, Andre Popescu of counsel to Shaknevich Law Group for the respondents.
So what do you have to say about this? What sort of eliminates a prejudice claim is the fact that there's this letter from the insurance company that they're involved in this, and from September 18th, 2023, but your colleague is placing the authenticity of that an issue. What ties that to Charter or to Spectrum, and that they knew about this in September of 2023?
Well, preliminarily, that argument was never raised before as to the authenticity. That's just being raised right now, I believe, at oral argument for the first time. But in any case, if one looks at the letter, which is the record at 89, it reads, "Please be advised that ESIS is handling the above matter on behalf of Charter Communications," and then there's a blank in the letter that says client, and it client : Charter Communications. They responded to the claim and gave every indicia that they were acting on behalf of Charter Communications. As far as the other arguments, I think there's a few things that were not raised in the court below, but I'm only gonna, I guess my time is limited. From all the case law that we cite, it seems that the primary consideration when the interest of justice standard is invoked is whether there's prejudice or not. In the court below, the only prejudice claimed by the appellant was that the statute of limitations had expired. Not only does that actually, under the case law, go in favor of the person seeking the extension, also this court has held that the mere passage of time, and we cite the case law, is not prejudice, does not equal prejudice. Unless the court has any other questions, I'm happy to rest on our brief.
Thank you.
Thank you.
Just very briefly, because the court has focused on that letter. The court below did not refer to that letter in its decision. And I think part of the reason, if I may assume, is that there's ambiguity about what knowledge existed to the writer of that letter, or more importantly, to my client. One would expect that if there's that type of communication, that we would have seen in the record a letter from the plaintiff either before or after that letter that says, here's the summons and complaint, here's a statement as to what happened to my client, here's her, something that puts notice on that unsigned letter, or the author of that unsigned letter, about what happened here. And I think the court below determined that there was too much ambiguity about who had notice and of what to
Well,
rely on.
I think the court also indicated that he was concerned, disturbed, and sort of was considering an interest of justice standard because you had waited until one day after the statute of limitations expired on plaintiff's causes of action to bring your motion to dismiss, and therefore plaintiff would be highly prejudiced. Now, I understand about statutes of limitation and all that, but still, when you wait one day, it raises the concern, certainly it raised the concern of the motion judge.
Fair enough. And the one thing, and I'm not going to try to convince the court that that was a coincidence, but we learned about the plaintiff's claim of service on charter in October and filed our motion in November. So this isn't a situation where charter just sat on its hands for some lengthy period of time. We acted quickly in a 3211 motion and raised all these objections.
Thank you.
Thank you very much.
Thank you both. Quintana against Quintana against New York State Office of the Attorney General.
Good afternoon. May it please the court. My name is Valdi Lacoul. I represent the plaintiff appellant, Sophia Quintana. I'd like to first address the negligent hiring, supervision, and retention claim that was dismissed by the court below. We believe that was an error. The Court of Appeals has stated clearly only a few years ago that an employer cannot shut its eyes, cannot put its head in the sand, and ignore the tortious practices of its employees if it had reason to know, if it knew or had reason to know.
Base that on the 2017 article? You base your...
We base it on the 2017 article, the subsequent sexual assault also that occurred by Mr. Khan during the time that he was at the Office of the Attorney General as well. But yes, primarily on the 2017 article, which goes beyond, at this 3211 stage, of showing should have known. It shows actual knowledge. There's no dispute here that Ms. James knew about that allegation. At the time, it was reported in the press. Her office at the time responded to that publicly, denying it, I believe calling the accuser a liar. And Mr. Khan continued to work for her. He then worked for her at the Office of the Attorney General, where there was a second assault. And the third assault is my client's assault, which happened in November of 2021. So there's a pattern. This is not just one incident. There's actual knowledge. That is all that's required here to meet the notice standard under 3211. And in the parallel Court of Claims action, that's exactly what the court held there, that was sufficient notice here. There's also a cumulative element to all of this that infers notice, and that is this. Each time there's an allegation against Mr. Khan about sexual harassment, there is a denial or an effort to sweep this under the rug.
Was there an investigation launched? And how does that play into this 1983 claim?
The first one, the first assault, there was an investigation. We know that there was an allegation that by Ms. James that there was an investigation. We have no idea what that investigation found.
But the fact that an investigation was launched, does that not satisfy?
No, it wouldn't. In other words, it wouldn't make that allegation not count if that's what the court is asking.
You're addressing the negligent hiring, supervision, and retention right now.
I am. Okay. I am. Yes. And so what I'm saying is it wouldn't make that allegation not count. And this court's decision in Wyatt is a case in which a plaintiff alleged that he had been shot by an officer during a traffic stop. And this court found that a prior incident where that officer shot a dog was enough to give the government notice, even though that that incident was investigated, and the government found that, basically he did it in self-defense. But that was enough to put somebody on notice. And again, at the 3211 stage, it's notice pleading. This is not a case where Ms. Quintana is alleging, well, Ms. James should have known or knew. There are actually facts behind this. And there's no requirement that the allegations be proven. Allegations themselves are enough. For example, in one particular case, there's an accusation of grand larceny. In a case where the employee then defrauded somebody out of money, this court and other courts have held that that's enough as well. There's also no requirement that there be shown a pattern. One incident is enough to put the employer on notice. And again, because this is at the 3211 stage, Ms. James can argue this was a false allegation. We investigated this, but at this point, we've had no discovery on anything. Secondly, I'd like to address the employment claims. The Supreme Court found that the employment claims were dismissed because there's no employment relationship.
A minute to this last one. Did the complaint state anything about dates for the article or for those allegations that were covered by that?
The dates of the New York Post article?
Right.
Yeah, I believe that was sometime in 2017. There was another article about that later as well. But the article went
Does the complaint state those dates?
The complaint does not state the dates. The complaint states the fact that the article had been posted and then taken down, and that was then reaffirmed by a subsequent New York Post article.
And it doesn't indicate that James was aware of that.
No, the allegations in the complaint are that James was aware of that allegation because it had been reported in the New York Post and denied the allegations. So in other words...
Yeah, no, I understand what you're saying. I just didn't think that there were any dates, and you've confirmed that there were no dates stated about the article.
Correct, because we can't find it, essentially. I'd just like to address the employment claims. There are two ways in which an employer can be held liable under the state and city laws. One is for discriminating against a job applicant. You don't have to actually be an employee. So an applicant who comes and applies for a job and is sexually harassed has a claim against the employer. Okay, they don't actually have to be an employee. And the second one is under this court's decision in Schmidt, which is a subordinate economic relationship where a prior employee who was discriminated against then is targeted for having raised a claim or protested, where they have a subordinate economic relationship. In Schmidt, this court held the fact that an employee was, her job opportunities and her standing in the industry was targeted essentially by her prior employer was sufficient to raise a claim under that test. Thank you.
Good afternoon. May it please the court. My name is Tracy Salmon Smith, and I represent the defendant cross appellant Ibrahim Khan. And I respectfully urge this court to reverse the trial court's denial of the dismissal of the Section 1983 claim and affirm the dismissal of all the other claims against Mr. Khan. I understand that the court has reviewed all of the parties' papers, and I just would like to take my time to address the 1983 claim under the color of law. So the core issue is whether Mr. Khan alleged conduct at a private fundraiser event constituted under the color of law.
He was there in a state vehicle?
He was not. That the claim, if we look at what was alleged in the complaint, right, it was alleged that Attorney General James arrived at the event in a car paid for by public funds, period. Then it says that she was joined by Khan, as well as her
You're
intergovernmental.
saying he did not arrive in a state car? Is that what you're saying?
Yes,
Okay.
that is what I'm saying. I'm
But
saying.
he did arrive in his capacity as chief of staff, right? He was
did
there in
not.
his official capacity, wasn't he?
He was not, because this was a after work event.
Even after work, people arrive at events in their official capacities.
Right, but
So my question is, was he not there? Did this have nothing to do with work?
it did not, because Attorney General James was attending the event to speak at a political fundraiser.
He was there with her. I mean,
Right, but she is not allowed to do that in her official capacity. And so this was.
And then that also adds to the distinction of public funds for the vehicle versus the state vehicle, right? Because she's not in her official capacity, so it's not an official.
She's not in her official capacity, but as Attorney General, she has access to being, she has her security detail.
So then I guess the question would follow, because this is a 3211 motion, like how do we draw that line? How do we know?
Right. Well, looking at the allegations in the complaint, what the judge at the trial level had relied on is he said in the decision on page R6 of the record, he said, given Khan's arrival at the event in a state vehicle, and that was the basis for why he denied the 1983.
Well, aren't there other facts as well? I mean, it's not, let's put that aside for a minute if he didn't arrive. You're saying he arrived at this event where there was going to be a speech by his boss, and he was not in his chief of staff role when he was there. He was just a private citizen there. That's why he was there as a private citizen.
Because the Attorney General her capacity.
So he
was not in her official capacity because it was a political event, so she could not be there in her official capacity.
So he didn't network for her, any conversations he had were not on her behalf or related to any business or in his position?
As alleged in the complaint, no.
So the demarcation that you want to make between being on business and being there in a private capacity, that may be important legally and in terms of how a public official conducts himself or herself, but does that matter in terms of someone who is a victim of alleged discrimination? I mean, the fact he's there in his private capacity, but for this person who works for the office, who's also there, so to speak, in a private capacity, the fact that you're both working for this government office doesn't disappear in terms of consideration of the city human rights law, does it? And my other question to you is that you say that he didn't arrive in a state vehicle, but doesn't she allege that he did?
No. Sorry, let me take your second question first, what the plaintiff alleges in her complaint is that James arrived at the event in a car paid by public funds, period. Next sentence, she was joined by Khan as well as her intergovernmental advisor for the borough of Manhattan, which is when they arrived at the event. So
I guess it depends how you read it, doesn't it?
It can, but when you read that she arrived.
They arrived separately. He arrived late. But you could also read this as saying that they arrived together in the car.
We do not read it that way, because then she could have just said that they all arrived in the car. She said specifically in the amended complaint at paragraph 27 that James arrived to the event, and then she talked about the other two that she had
getting
joined
back
her.
to the first question, do we draw this line between public and private capacities when you're dealing with an employee who is allegedly victimized by something that someone who works for the office does?
At the time of this event, Ms. Quintana was a former employee of the Attorney General's office, and Mr. Khan and the Attorney General were there, not in their official.
Can discrimination apply to former employees, or does it have to only be current employees?
It can, it would need to be current employees, or, yes, it would have to be current employees.
And you're talking about the 1983 action.
Well,
right now, you've been focused on that one?
Yes, I was focused on the 1980.
And you're under the, where the language is operating under the color of law or conducted state business in his official capacity. That's what you're challenging.
Yes, that is, Your Honor. And I see that my time is up. I do have some rebuttal and.
Okay, well, you have rebuttal.
Thank you, Your Honors.
Good afternoon. May it please the Court, Dana Sessions on behalf of the Office of the Attorney General and Attorney General James. I just want to take a step back for a moment to frame what we've been talking about, which is, as plaintiff alleges, an incident that occurred at a political fundraiser where Attorney General James was giving a speech in support of her campaign at that time for governor. These claims try to take what is personal conduct and a personal incident that is alleged between Mr. Khan and Ms. Quintana and convert them into workplace misconduct claims against the office and Attorney General James. They fail for all the reasons that the trial court found and for the additional reasons that we've submitted in our papers.
Does misconduct have to take place only at the workplace?
It does not, Your Honor, but it does have to have a nexus to the job and to the workplace environment. And the plaintiff needs to be in a workplace in an employment context, which is what the law requires, and here she was not.
Are you speaking just about Attorney James, or are you speaking about J and Y or any of
That's
the others? Right?
an excellent question, Your Honor.
James.
So let me clarify. I'm speaking only on behalf of the Office of the Attorney General and Attorney General James. The allegations as to my clients relate solely to the allegations at the Someday Bar on November 17th, 2021. There are separate allegations about a different application for employment and a different set of facts that my colleague is going to address. So back to your question, Your Honor, in terms of the discrimination laws, they need to have an employment, it has to be in an employment context. And I think Your Honor may have asked before, former employees, job applicants and the like, there was no employment action taken, there was no employment context in connection with the Office of the Attorney General or Attorney General James during the interactions between Mr. Khan, the alleged interactions between Mr. Khan and Ms. Quintana.
So plaintiff focused in his argument, at least to some extent, on the negligent hiring and supervision, and saying that your client was aware of prior incidents through New York Post articles, which were prior to this. And so the plaintiff was, I think, a former deputy press secretary for the Attorney General, who I would think would go to events where she's speaking, running for a job. Is he wrong that these fall under that situation? I mean, could you deal with that negligent hiring question?
Yes, absolutely, and that was the next point I was going to get to, so thank you. In terms of the negligent hiring claims, the trial court got it right. The allegations of propensity based on a single New York Post article that the complaint itself pleads was retracted are insufficient as a matter of law to provide notice of propensity to commit sexual assault. The cases on which plaintiff relies, and they rely heavily on Wyatt and Chichester, which are both decisions out of this court, have many more facts alleged as to the propensity allegations. They are not single incident cases. Now, single incident may be enough in certain circumstances. We're not contesting that. But here, the allegations are way too thin. And I want to address one other allegation that my colleague on the other side raised, which is this issue of a subsequent assault that is alleged nowhere in the complaint as anything the office or Attorney General James knew at the time or should have known. And so there are no allegations to that effect. The allegations in the complaint reflect that the Attorney General's office, the Office of the Attorney General, and the Attorney General learned about Ms. Quintanar's allegations when she came forward in September 2022, immediately launched an investigation, and at that time learned of other allegations. But there is nothing in this complaint that provides notice prior to that point in time. And so hopefully that addresses Your Honor's question there. Just coming back to on the negligent hiring claim, one other point I wanted to make, which is in our paper, so I'm not going to belabor it, but there are also other defects with that claim with respect to proximate causation and the lack of a nexus between the alleged negligence and the alleged harm. And also, from the face of the complaint, there is governmental immunity for these claims because the claim that is alleged is discretionary and therefore protected. So I just wanted to make those points. In addition, I would just close out on the employment claims with respect to the Office of the Attorney General, specifically, as I noted, the allegations are simply that they were discussing politics and other things that night, and that Ms. Quintanar said in her complaint she was, quote unquote, in the market for a job. There was no discussion of a particular opportunity at OAG. There was no discussion about what she was interested in doing, what might be available to her. And so there are no facts pled from which to infer that she was in an employment context or a job applicant that evening. Unless the court has anything further, I'll sit down. Thank you.
Good afternoon. Ivan Smith for James of New York. The key issue here is James, New York. Khan or Ms. Quintana were never an employee of James, New York. And without being an employee, you can't have a negligent hiring claim, you can't have a negligent retention claim, and you can't have a negligent supervision claim. As the minute complaint clearly states—
If you're applying for a job, none of these provisions can have application to you?
I'll get to with the hiring of the job. In the hiring of the job, there's two allegations in the complaint. One, that the November 17th, 22 political event was an application. Just as my colleague just succinctly said, that the only conversation was, I'm in the job market. It didn't say for what job, for what entity, for whatever. She didn't even know whether or not James, New York even had a position that was open. So you cannot say that meets the criteria for a job application. The second issue was 10 months later in September, she heard that there might be a job in the communications office and that she said to her mentor to maybe to look to see, was there a job? The problem with that is that you have to at least be an applicant for some type of job, that the process, even though it doesn't have to be a job posting, you have to be a process that the employer, James, New York, found to be acceptable. We don't know who the mentor was not an employee of James, New York. We don't even know if the mentor even spoke to anybody from James, New York. And so without that, you cannot find that she was a job applicant, and that's why the court found that she could not make that claim. So to be able to find James, New York again, even for the employment issue, they have to be the employer. As he said, starting off with the negligent hiring claim, the propensity, she was never an employee of James, New York. Khan, at the time of the event and at the time of, quote, the second application, was not an employee of James, New York. What they try to assert is this de facto advisor. If you allow that to happen, then you're allowing everybody to be subject to discrimination claims without being the employer. You have to at least say that the person was an employee. So if the person is not an employee, you can't say, we hired them, fired them, or we didn't retain them for that. And that's the main flaw in his argument. When the complaint was first alleged, he alleged the same de facto, and we filed a motion to dismiss. In response to the full motion to dismiss, he amended the complaint. In amending the complaint, he still never alleged that Khan or Quintana were ever an employee of James, New York. And without that fact, that one issue, you can't find on any of his claims. And that's why the court below was absolutely accurate in dismissing all the claims. Unless you have.
Thank you.
I'd like to address the former employee piece. Under my colleague's arguments, somebody can take a resume from someone and then set up an interview, and then during that interview sexually harass them, and that would not constitute sexual harassment under the state or city laws because
Is
there's
that
no
what's
actual
alleged
job.
is that what's alleged, that Khan took the resume?
No. What I'm saying is that somebody who is applying for a job is protected under those laws. And as part of that protection, they're entitled not to be sexually harassed. And it doesn't matter if there's an open job opportunity or not. If it's a failure to hire claim, that might matter because you can't be denied a job that isn't available. But if the allegation is I'm allowed to apply for a job without being groped and forcibly kissed, that is protected.
But she wasn't applying for the job at that time.
No, what she was, when at the night on the bar, she was asking her former boss.
Well, what difference does it make if it was her former boss?
Because context matters. She had left the job. He is the one who hired her at the Attorney General's office. He supervised her. She left. She apologized for the way she left. She wanted to make sure it didn't interfere with her future job opportunities. She sees him at this event. The allegations in the complaint, like in Schmidt, that this court's decision in Schmidt, those events are job-creating opportunities. She goes to him and says, I'm in the job market. He says,
How do you link him to James New York?
Because the allegations are that he was the former campaign manager for James when she was running for Attorney General, that he then became her chief of staff. And also there's an allegation that in November 2022, when she applied for an actual job at James for New York, he torpedoed that opportunity by saying, while he would like to work with her, somebody else at James New York may not. That suggests...
That shows that he's an employee of James
That
New
shows
York?
that he has authority consistent with supervisory employee status, and on 3211, we should be able to explore that.
If he was getting paid any fees for that
Or had the
advisory role?
authority of being a supervisor. In other words, it's not just getting paid, right? It's the issue of control, right? And if he can act on behalf of James for New York, if he has hiring and firing power.
Are you saying that he had an advise and consent role in who gets hired?
Yes, we do. We do allege that. Sorry.
I just wanted to ask, what about the argument that she really wasn't an applicant? That there's not a formal application so that you never get over that hurdle?
Yeah, the case law is pretty clear. The application process is required where there's a job posting. But as the Second Circuit has found and other courts have found, you can't require somebody to apply for a job that's not posted, especially where the real world evidence is that it's these informal processes.
It's the industry practice of how.
That's exactly right. And that's again, this court's decision in Schmidt. Schmidt actually says that's an art world where these kinds of events are where people get jobs, and this court found this subservient economic relationship test met. Okay?
Thank you.
Thank you.
Wait, there's rebuttal. Did you? Who's next?
Sorry. I
Everybody's
believe
leaving.
that,
It's time to-
no, I believe that everything was covered, so I was going to say I didn't need to. Okay, thank you, Your Honors.
City of New York versus Exxon Mobil.
May it please the court. Claude Platten on behalf of the City of New York. The city alleges that the defendants misled New York City consumers about the lower emissions of their products and their corporate efforts to address climate change. They did this to induce New Yorkers who are concerned about climate change to purchase their gasoline and other products. The Supreme Court should have held that those allegations state a claim under the Consumer Protection Law.
Guggenheimer, is that still good law, or has has there been a shift away from that standard that was in that case?
Well, two things. First, it's still good law until the Court of Appeals says otherwise. That's the last statement from the Court of Appeals about the consumer protection law standard.
What about Oswego?
Well, that's a general business law claim. The Supreme Court may have been right that the Court of Appeals, if posed with the question now, might say something different, but it hasn't, and Supreme Court didn't have license to.
The consumer protection law references the Federal Trade Commission, does it not?
It does.
And what's the Federal Trade Commission standard on this?
It's the reasonable consumer standard. And I just want to be clear.
So how do you get out of that?
Well, right. I don't think we need to get out of it because just to be clear, our position is that the standard doesn't matter for this case. We want to be clear that we still think Guggenheimer is the standard, but that it doesn't, the plausibility of our allegations doesn't turn on what
Do you allege that any of the, that there's actually anything stated by the defendants that was false?
Not false, misleading, Your Honor. So what they said was, no, I'll start with the product greenwashing, because I think this is, they repeatedly said that their premium products with their high-tech additives could lower emissions.
To clean the engines, right?
That's the mechanism.
Sort of like STP of 50 years ago?
That was the mechanism by which it would lower emissions. And yes.
And there's nothing that's been demonstrated to be not true about that, right?
No, and it doesn't have to be
no
false.
Allegation that it's not.
It has to be misleading
In fact,
or
those
deceptive.
additives did lower emissions.
Well, I think
Does it have to be false?
it does not have to be false. It has to be deceptive.
Misleading.
Misleading. And the defendants are...
How are those statements misleading?
Well, first off, just as the Federal Trade Commission's Green Guides say, when you make sort of broad, unquantified assertions about environmental benefits, you invite the reasonable consumer to conclude that those benefits are meaningful, and some reasonable consumers may take the impression that they're more meaningful than they really are. And they say you should not make those kinds of statements. You should quantify the benefit. Defendants are now saying no reasonable consumer would have thought that this was, I think, anything other than negligible, but that's just not the case.
Why aren't these statements really puffery?
Because they're making factual assertions that these additives, this product, these premium products, produce lower emissions. That's not just a sort of statement of opinion or aspiration or sort of something that no reasonable consumer could
But you're
think
saying that they do in fact reduce emissions.
Well, they
May not. It could be they don't meaningfully reduce emissions, but it's true that they do reduce emissions.
Right. Well, the reason these statements are misleading is because reasonable consumers could have come away from these generalized statements believing that the benefit was significantly more than it is. And the FTC has recognized that that's a basis.
Significantly more than it is, or just what it is? I mean, you're saying that they are saying that, okay, they reduce emissions. So I'm going to buy that gas because they said it reduced emissions.
Exactly.
Is there something beyond that? I mean, that's not more than, that is what it is. That is what it says. It may not be what it is, but it is what it says.
Well, I think the defendants are not being clear at this point whether there's really any non-negligible benefit, but the point is when you say lower emissions and you don't specify how much, you invite consumers to sort of believe that it's significant and it may not.
Your case is premised on the following, is it not? That someone who cares about climate change and someone who cares about the use of fossil fuels will have seen these commercials or these representations and walk away saying, oh, I can drive my car now because of the gasoline that Exxon or Shell or BP is coming out with. They're not really doing any harm to the environment.
No,
that's sort of the thought process, is it not?
It's not, Your Honor. To be clear, the thought process is that New York consumers who care about climate change, who understand that when they fill up their car with gas, they're contributing to climate change, would be susceptible.
And now they're going to think they're not.
No, they're susceptible to statements that suggest that these products are better than others and that is going to manipulate them into choosing these products.
So it's enough if the statement causes them to choose, instead of gas A, to choose Exxon.
Exactly right.
And that's all.
That's the basis.
It has to be enough to motivate them to buy.
That's enough to state a claim under the consumer protection law for misleading advertising. If I could just
And the reason it's misleading is because?
is because it invites reasonable consumers, as the Green Guides make clear, to believe that there is some significant, meaningful benefit that they will be.
Well, they do say that there's a benefit.
Producing lower emissions, just to be clear, that these are less harmful products than others. And that
Can I just get him to, I just want to hear the
that climate conscious consumers are looking for less harmful options, and these statements will lead them to believe that these are less harmful options and choose them to choose.
Are they less harmful?
They are not meaningfully less harmful. They're not.
Meaningful.
Not meaningful.
They're not. No, our position is they are not benefit. Just like low tar cigarettes are still going to kill you, that they are not more. They are not less harmful. And they.
So you've the Exxon, BP, Shell, three of the major. So this sort of supposes that these companies were pushing business their way at the expense of some other company. That's what's misleading, right? Because they're going to choose these products over a different product. Which gasolines are there that, who else is in the market that doesn't have additives in their gasolines? I mean, that you sort of you've got the big three here. Who else is there?
Well, they're all competing for the same customers. They're competing with each other.
And they've all got the same. They've all got the same additive.
Well, they're all claiming.
The question is, are there other ones? I know if I'm driving on the highway, I see a lot of names I don't recognize. So there are others. So I mean, choosing one of the big three, I choose big A instead of big B, or I C, or that doesn't matter. But if I'm going to someone else that's not one of them, and I change and go to them, then
That's right. And then there are statements that the defendants highlight, which is that these are better than other gasolines that don't have these new additives. They're competing against each other. Our additive is best.
So in New York City, the motive of this case was Exxon, BP, Shell. You shouldn't be doing this because we want to protect Company X that's selling gasoline, whoever that may be in New York City.
No, the concern is that defendants are making misleading environmental claims that deceive New York City consumers, and it's a violation of the consumer protection law to do that. At this point, we don't have to. It doesn't have to be at any particular expense. The harm is the deception of consumers who are concerned about climate change, are being told these products are less harmful, and they're not. And they're being induced to or manipulated to
in other
buy
words,
these
they shouldn't be using things that aren't true to get people to pay for their gas.
That's the heart of it.
That's all it is?
Consumers should not.
Is that enough?
This is statute. We're enforcing the statute to protect New York City consumers from deceptive advertising. That's the purpose of the statute. These claims deceive consumers to induce them to buy these defendants' products.
And it is premium, I think, is what you're saying. So it is more expensive, but that's not really what you're saying. You're saying they're simply induced to buy this gas because they believe that they are doing something a little bit better for the environment.
Yeah, and I think we're protecting the marketplace where competitors in the marketplace shouldn't be getting business by making false or deceptive and misleading statements that mislead consumers. And the integrity of the marketplace requires that people tell the truth. That requires them that they not use statements that may mislead consumers or create.
And you're saying, one more time, I'm sorry, and the misleading is because they're saying it, but causing people to not overstate, but to believe it's greater than it is. In other words, they're saying it reduces or whatever it is, but you're saying that the consumer is believing that it's doing more than it simply says.
Our position is that it's not meaningfully less environmentally harmful, and consumers could come away believing that it is.
So will you have to, in order to, if we allow your claim to be reinstated, are you saying that, will you have to, in order to win this case, prove that, bring in drivers that go to a Shell station because they think that Shell because of their advertising, rather than some other location in New York City? I mean, I don't know if you drive in New York City, but you don't really have too many choices of gas stations because there are hardly any. And so if I could find one, I'm like so happy. And I don't know if, and I'm concerned about all these things. But what do you have to prove? Just that they're doing that, end of story? Do you have to prove there's damages? I'm just trying to see where it's going.
Right. The violation occurs when the defendants make statements that have the capacity to mislead New York City consumers.
You'd have to prove.
We'll have to prove that.
So you'd have to.
With discovery, with expert testimony, we'll have to show that these were misleading to a reasonable consumer. All we have to show at this point on a motion to dismiss is that we've plausibly alleged that consumers could have been misled by these statements. And when we have the green guides from the FTC saying that it could be a misleading statement, when we have decisions from other jurisdictions involving some of these same allegations, allowing the claims to go forward on a motion to dismiss, I don't think you can say, as a matter of law, as the Supreme Court did, that these claims could not plausibly have misled, that these representations couldn't have misled. I haven't gotten to talk about the corporate greenwashing. If I could have a minute.
You have some rebuttal.
Okay, of course. Thank you.
Thank you, Justice Renwick. Canon Shanmugam of Paul Weiss on behalf of respondents. May it please the court. I think that the court has a good understanding of the nature of the claims here. So in my limited time, I want to address the two primary issues that my friend Mr. Platten addressed during his argument. First, the question of the appropriate standard. And then second, what I think is really the critical question with regard to the product-related claims. What exactly is it about these statements that makes them false or misleading? And at the outset, picking up on Justice Friedman's question, I don't think that there's any doubt that there's no claim of falsity here. I think that the city recognizes that what was said was factually accurate as far as it goes. So I want to address the city's theory of why these statements are misleading. But first, let me just clean out a little bit of the underbrush here on the question of the appropriate standard. I think that there is no doubt that notwithstanding what the Court of Appeals said in Guggenheimer, whether or not that was a holding or just a passing statement, that the Court of Appeals has, as Justice Pitt-Burke put it, shifted away from that standard. And in the colloquy with Mr. Platten, you obviously walked through the Court of Appeals' subsequent decision in Oswego, and then this court's decision in City Line Auto Mall, which applied a reasonable consumer standard to consumer product law claims. The bottom line here is that the standard is the same across the consumer protection law, the general business law with its two provisions, and the FTC Act. That is the familiar reasonable consumer standard. And I'm a little bit perplexed by the city's suggestion, after many pages of arguing for an ignorant or unsophisticated consumer standard, that it turns out the choice of standard doesn't matter at all. If so, it's unclear to me why we're having this discussion, but the reasonable consumer standard is a familiar one in the law, both in state courts and federal courts, and of course the parties rely on many cases that apply that standard. So that brings us directly to the question of what it is that makes these statements misleading. Now, the city's original theory was that these statements could create the impression that these products actually reduce emissions across the board. The city, I think, has wisely moved away from that theory in light of what Justice Patel said in her opinion in the Supreme Court, which was quite simply that the city itself, starting with the very first paragraph of the complaint, alleges that consumers are well aware of the fact that fossil fuels cause climate change. And so the notion that consumers could...
Did they ever say, is there ever a claim that what you alleged was not true, or just as counsel has emphasized to us today that it's a misleading, that maybe you overemphasized what these gas products?
I think the theory has been that it is misleading, but that theory has morphed away from the theory that a consumer could be misled into thinking that these products reduce climate change into some sort of theory about the magnitude of the effect of these products. Now, I think, not to get too particular about it, but I think that there are actually two theories that we have heard from Mr. Platten and from the city in its brief. The first is this theory about a so-called negligible or meaningful benefit. I think, putting it as best I can, I think the theory is that if the relative benefit of these premium products compared to ordinary gasoline products was somehow de minimis, that maybe that makes the statement misleading. But the critical point here, and this is not a waiver point so much as it's a point about satisfying the 3211 standard, is that if you look at the complaint itself, it nowhere alleges that, in fact, the effect here was de minimis. It doesn't cite any allegations to support that proposition. And in particular, I would point you to the very helpful chart at the end of the complaint in the appendix, starting at page 96 of the record, which walks through every one of the allegations and at the end explains why they're deceptive. And you would search in vain for any suggestion that there was a misleading aspect to this because the effect was de minimis. And therefore, what I think is really going on here, and this is where the reliance on the green guides comes in, is that the city is really saying that we, the three companies before this court, had an affirmative obligation to quantify the benefit. At points in the brief, it's almost as if the city is saying that there is a unique rule in this particular
Or to warn the public that there's still a danger from fossil fuels.
Well, and that, if you put it that way, or if you put it as just a discrete requirement to quantify this effect, the outcome is still the same. That is basically an omissions claim. That is basically a theory that there is some affirmative duty. There's nothing misleading about what we said. Rather, there's an affirmative additional duty to say something more in this context. And you just simply cannot get that from the consumer protection law. You can't get that, frankly, from any of the broader consumer deception laws. And that would be a major expansion of the law to say that in certain contexts there's an affirmative obligation. It would be like saying, in the context of the example that is cited involving, I think, Diet Coke or a diet soda, there's an affirmative obligation to say how many calories there is in the product, or else your statement is misleading. And I think that that's really what the city's theory boils down to. But the city obviously doesn't want to say that, because once it does, it has a really obvious legal problem with its theory. And the last thing I would say just about the specific statements, and here I would point you to pages 10 to 11 of the record, where Justice Patel lays out the statements in a somewhat more concise form, is that all of the statements of the three defendants have a common theme here. They were carefully worded in relative rather than absolute terms. I think I would recognize that if you made a statement that said, you know, these are low emissions products, that you could, at least in theory, be susceptible to a claim if in fact the emissions were high. But all of these statements were about lower emissions, higher emissions, fewer emissions compared to regular gasoline products. And the statements didn't stop there. They went on.
Even if it was de minimis, you're saying it's not wrong.
The statements did not in any way quantify the magnitude of the relative impact. And again, it's critical here, I think, that it's a relative impact, and the statements went on to walk through in precise terms the mechanism by which these premium products work, namely by providing for cleaner engines, in the fancy scientific language that Shell used, the ability to clean up gunk. And it explained, ExxonMobil, for instance, explained that the benefits may vary depending on vehicle type, driving style, and gasoline previously used.
Saying that something is 2 times more clean, is that quantifying it?
So I think that the important thing here, and I do think that the city, with respect, is being a little bit misleading here, is that when you look at that statement, it is that the product keeps an engine 2 times cleaner for better gas mileage. So that actually, by its terms, isn't a statement about emissions at all. It's just a statement about the mechanism, whereby premium gasoline works and provides benefits.
So I just want to bring us back to the posture of this case. Even given that this is a 3211A5 and 3211A7, should this not proceed given that posture?
There are statements under 3211 that are not actionable as a matter of law. And at a minimum, I think it is incumbent on the city at the 3211 stage to identify the mechanism by which the statement could be proven to be misleading. And I think that simply hasn't been done here because there is no actionable theory.
I just want to ask you, I'm curious about, it seems to me that there are constitutional issues involved in this case, which was mention of it, but it seems to have fallen by the wayside. How did that happen?
Well, I think it probably largely fell by the wayside because we made that argument primarily with regard to the non-product related statements. And I'm happy to answer any questions that the court might have about those. Our primary submission is that Justice Patel got it right by saying that the requirements
You
of
felt
the
no need to address it.
There's no need to address it. We do bring it in as an avoidance argument, a constitutional avoidance argument as to why her interpretation is correct, because if you blow the covers off the requirement that the statements be made in the connection with the sale of consumer goods or services, then you're really going to start to have a constitutional problem because you're getting into statements on issues of public policy that have no connection with the sale of a particular product. I will say, though, just to underscore one related point, Justice Friedman, you made the point that many of these statements are puffery. I don't think that that's true with regard to all of the product-related statements. I think we would agree with Justice Patel that only some of those statements would qualify, but we do think that there is a puffery aspect really as to both categories of statements here. And the doctrine of puffery is not unrelated to the underlying First Amendment concerns with making statements of opinion, statements that aren't factual, nevertheless actionable under a consumer deception statute. So we would ask that the Supreme Court's 3211 ruling be affirmed. Thank you.
So a few responsive points, and I'd really like to just touch on the corporate greenwashing too. So to start, my adversary, my friends, referenced the green guides, but didn't just point you to what those say, which is, and I want to point just to clarify what our theory is by reading from it. It says, unqualified general environmental claims are difficult to interpret and likely to convey a wide range of meanings. Such claims are likely to convey that the product has specific and far-reaching environmental benefits. It's highly unlikely that marketers could substantiate all reasonable interpretations of these claims, and they should not make unqualified environmental benefit claims. It's undisputed that that's what they did here. They made claims that invited reasonable consumers to believe that there was a far-reaching environmental benefit, or one that would be meaningful to consumers who are making choices. And that's the theory. They are not arguing that we didn't preserve this point. I think that's correct. The question for motion to dismiss is whether the allegations sustain a cause of action. They do. We articulated the theory we're pursuing here in our motion, in our opposition to the motions to dismiss and an oral argument. So it was properly in front of the court, and that is the theory we're advocating here. The fact that they said these were relative benefits, that's the point. The fact that they said the mechanism was cleaning the engine, a reasonable consumer could think that could be a plausible way to lower emissions. That doesn't get them out of the problem. That they said it was by cleaning gunk out of the engine. That the consumer could think, well, that's how it works. So just briefly on the corporate claims, the Supreme Court made a holding on the meaning of the statute that's really important and could have far-reaching implications, saying that corporate claims about corporate environmental efforts to combat climate change are categorically outside the reach of the consumer protection law because they don't reference the product, the consumer product. And that is a construction of the phrase in connection with that would really just blow a hole in the consumer protection law's reach. The City Council intended this to be a comprehensive substantive ban on all forms of consumer fraud. Modern consumer fraud can sometimes be sophisticated. It can play on consumers' desires. It can try to motivate them to make purchases without specifically mentioning a product. And here, these defendants, we allege, they knew that consumers were concerned about climate change. They spent many millions of dollars directing ads to consumers about all the great things they were doing to offset climate change. These ads were meaningful to consumers making decisions to purchase gas because they suggested that the defendants were taking steps to mitigate or offset the harms that you cause every time you put gas in your car. And also, there's a close association between defendants' products and their brands. When you hear Exxon, most people think gasoline. So if you put a positive, burnish the image of the company as environmentally friendly, it puts an aura of less environmental harm on that gasoline. And just to the First Amendment points, Your Honor, they're now just saying you should essentially construe the statute in an unreasonable way, categorically put all of these claims outside the reach of the consumer protection law, just because they can envision a situation where some claims of policy or position might be implicated. The court going forward can take any reason, can adjudicate any argument that a certain claim is not just commercial speech, but is something else and protected by the First Amendment, and deal with that on a case-by-case basis. You shouldn't construe the statute in an unnatural way prophylactically to avoid the mere possibility of that. And I ask you to reverse and reinstate the complaint.
Thank you. Thank you both. Szer versus Con Edison.
May it please the court, my name is Dan Ratner. I'm here on behalf of Con Edison. We're asking the summary judgment order denying our motion to be reversed because the court, in our view, erred in holding that Con Edison had some sort of an affirmative burden of stating that a record search, that no work was performed there. What our record searchers said was the business records that are kept in the ordinary course of business by Con Edison did not show that any work was performed. We didn't produce a witness to, in a sense, say, well, we were walking around in the area of East 22nd.
So I don't think that look, Chong, I think, is the one you're speaking of, and she, I think, left more questions unanswered than answered because she just confirmed that Con Ed was working all over the place, near there. But and she didn't say that Con Ed caused it, but she didn't say Con Ed didn't cause it. It's just they were there.
What she said was the loan opening ticket. That's the document that shows that the street was open. That's what that document would say.
Right.
The loan opening ticket that was revealed during that record search did not relate to the corner, the northwest corner of Park Avenue and East 22nd Street. So there were some permits for work to be performed in that area, but there was no corresponding opening ticket, which is a common thing. People get permits and then the work doesn't get done. And she couldn't go beyond that because that's the way it works. She's basically saying if there's no opening ticket related to that street corner, that means that the street was not open there. That's how it works. So her position was fairly simple. She was not an eyewitness, obviously. So she couldn't say no work was performed there. She could say what a record search revealed. And to require Con Edison to do more than that would sort of create an impossible burden to prove a negative other than that. No work was performed there because the business record showed that there was no record. There was no work performed there. The only other thing that came up was the existence of street markings. We showed that the blue street markings that was labeled 2017, a year later after the accident, were in fact communication company markings, not Con Edison's markings. We also showed...
I'm just going to jump you to something else because they have a cross appeal too, and we're going to just do these all together.
Sure.
With regard to Mickelstein and wanting more discovery. Mickelstein seems to, first there was nothing about that area, and then he came back and gave additional testimony that I guess there was conduit under. It was about whether there was conduit under.
I believe there was some problems with the materials that he had in front of him during the first deposition. He came back and did a better job. He was basically reading from the plates, which are the maps of the area, and saying, here's where our subsurface equipment is. But
and there was some indication that this area has been paved over.
Well, that's...
So they're asking for discovery to find out, well, who did repave it? Who took care of that?
That would fall under the category of subsequent remedial measures, which normally would not be discoverable unless there's unless it is a dispute over control, right? We didn't have control over the surface level of East 22nd Street. That's the city of New York.
So you're saying you didn't pave it?
No, we didn't have, there's no evidence that we ever had control over that area. There's no, just because we had equipment under the street doesn't mean we had control over the street, if you will. Simple as that. Thank you, Your Honor.
Thank you.
If it please the court, good afternoon, Your Honors. Jeffrey Meltzer for the plaintiff. If I may jump right onto the point that was just made by counsel, there are Con Ed markers there, and they're all over the place.
Those are those blue markers that were in the street?
Yes, Your Honor. There was some question because there are markers all over the place, but the markers that I gave the pictures of were clearly in the area where the conduit runs.
And they're not the royal blue markers, they're Con Ed colored markers.
That's what the Con Ed, that's what the pictures in the record say. And I know it's inappropriate, but I took those pictures. I know that's Con Ed work because the Con Ed markers are there, and that's what the markers are supposed to be there for. Now, when Michelstein came in and testified, yeah, there's conduit running right there, and then I brought the documents in to Ms. Chung. I know I'm jumping around a little bit, and there's the mention of cut from roadway. There's a permit that says CFR, and I asked Ms. Chung, what does CFR mean here on this work order? And she said, oh, I have no idea. But clearly a cut was made. Otherwise, why is Con Ed paving there? And the pictures as to the defect show two saw marks running right where there's an electrical designation. Now, why did they stop and leave those two saw marks? Because as we can see, if you compare the first picture against the second one, they cut in the wrong place. They needed to be nearer to the curb. So when they got to the right place and they actually repaired what they were supposed to repair, then they paved over the whole thing. Why would Con Ed pave over a defect that they didn't create? I think it's a disingenuous argument that Con Ed is making here, and they're trying to have it both ways. They're saying, it wasn't us. We've done this document search, and it seems to say that we're not us, but we're not going to give you any of the records about the work that we did there so that you can't prove that it's us. So they're almost sealing, and just to address Ms. Chung's testimony for a bit, I brought additional documents from a FOIL search that showed that Con Ed did multitudes of work compared to what Ms. Chung brought. And when I asked Ms. Chung, wait a minute, what are the parameters of your search? She said, oh yeah, it's a limited search. It's about, you know, so much distance and only so many time period. I said, who set those time periods? Oh, well, that's just how we do it. So Con Ed literally, and then the court very clearly identified, Ms. Chung's testimony is good for nothing as to proving anything. And for 35 years, I've been playing this game with Con Ed where you get the record searcher, they come in, they give you this little bit of documents. I get a whole bunch of other documents from the FOIL. Then I ask her to talk about them, and she's like, I don't know what these are. So in terms of proving a summary judgment, entitlement to summary judgment, they failed.
So what about the post-accident repairs, which we know are not generally discoverable unless there's some issue about ownership or control?
Control, Your Honor. The word control, I think this court should make a statement to clarify. It seems to me, in terms of logic, if you cut the street, you're in control of it. And clearly, Con Ed has cut the street, and if you've paved it, you've taken control of it. And just as, and it's an odd argument that Con Ed's making. They're saying, oh, well, it's a whole bunch of different markers there, but there's no issue as to control. How could that be? Obviously, people, I see my time is up. May I just conclude? If there are a whole bunch of different markers there, and somebody did work there, and we know that Con Ed markers are there, Con Ed should at least produce the records to say why they paved there. And definitively, at least at one time, say, our records show no control. All of Ms. Chung's records and the records I produced through FOIL show there's probably was control. But then we need to get a definitive word. Because we're never going to know exactly what happened. There's no video, there's no exact timesheets. There are reasonable inferences to be made. And if Con Ed paved right over where they made those saw cuts, the reasonable inference is that it at least should go to the jury.
Thank you. Thank you both.
Thank you.
Wait, I'm sorry, you have 1 minute. Yeah.
I know we're late here.
No.
Council keeps saying that Con Edison paved over the road. There's no evidence that Con Edison paved over the road. These blue markers that are supposedly are all over the place.
Right.
We had a witness submit an affidavit, pages 690 through 696 of the record, where he personally examined those blue markers that are depicted in these photographs and said they're not Con Edison's markers.
Well, they said the
Counsel is
royal
not a
blue
witness.
ones were not
Sorry?
Con Ed. Said the royal blue ones were not Con Ed's.
No, he looked at all of them and he said they're royal blue and they are those would be telecommunications. Like the other thing I want to say, the red lines, whatever, the evidence, that's common practice. If someone's going to cut the road, they want to know what might be under there. Con Ed may or may not have marked that road to warn somebody else. It happens all the time.
What about the post-accident repairs to show control? What about that?
Well, the problem is that we didn't, there's no evidence that we were the ones to cut the road. That would mean we were under control of the road, and therefore you would want to know why it was then paved over. But since there's no evidence that we were in control of the road, the markers aren't ours, and the subsurface equipment has nothing to do with it. That means, and there was no permits, no opening tickets. That means that's why there's no control, because we didn't open the road in the first place. I know it's a little circular, but I think I'm right. Thank you, Your Honors.
Thank you.
Oh,
Did you have?
Oh, I'm sorry.
Yeah, I know, but I don't know that.
In the posture, I don't know if I get rebuttal too.
If you want it, I think I gave it to you. You had 1 minute.
Okay, thank you, Your Honor. Just to address that point again, these arguments do kind of fold on to each other. And I would just leave the court with the basic concept that there are Con Ed markers there, there is Con Ed equipment there, the pavements match up with the equipment. There's a reasonable inference to be put before a jury. And I honestly hope that my appeals are moot because you just uphold the summary judgment denial. But if you are considering overturning that, I believe that the plaintiff has been denied the records that would at least make some kind of definitive statement as to why or if Con Ed truly was there.
Thank you.
Thank you.
Thank you both.